This is the brief on Philippine property crimes. So the notes we're looking at today break down exactly how the law categorizes stealing, showing you that the specific method someone uses to take property drastically changes their charge and the penalty. First, we're looking at the basic physical act of taking your stuff, which splits into robbery and theft. See, robbery involves violence, intimidation, or using force upon things like breaking a window. Theft, on the other hand, is simply taking personal property without consent, but without that violence or break-in. Think of it kind of like this. If someone smashes your locked door to grab a laptop, well, that's robbery. But if they quietly swipe an unattended laptop right off a cafe table, that's theft. Second, we've got qualified theft, and this one triggers much harsher penalties. This kicks in if there's a grave abuse of confidence, like a domestic worker stealing from their employer, or if someone takes specific protected items, like a motor vehicle, cattle, or, believe it or not, even coconuts from a plantation. You really got to notice what's happening here, because the law isn't just protecting property, it's severely punishing that intimate betrayal of trust. Finally, we shift over to psychological manipulation with estafa, which is basically swindling. In standard theft, someone takes your stuff without asking, right? But in estafa, you literally hand it over willingly because you've been tricked through deceit or an abuse of confidence. Estafa is really the crime of the con artist, where the weapon of choice is a lie instead of physical force. Ultimately, criminal law shows us that how a criminal steals, whether through physical force, deep betrayal, or clever lies, matters just as much as what they actually take.
Two individuals decide to steal identical items. The first quietly pockets an unattended watch and walks away. The second shoves the owner aside to take that exact same watch. The physical loss is identical, but the legal consequences are severely disparate. The first offender faces a minor penalty. The second triggers a chain of legal multipliers that can culminate in reclusion perpetua. Under the Philippine Revised Penal Code, criminal liability for property crimes does not scale with the value of the object lost. The law punishes the precise methodology the offender uses to secure it. Look at this decision tree. Title 10 of the Penal Code operates as a rigid legal matrix. Determining exact criminal liability requires tracking a specific set of variables: the offender's intent, the physical execution involving force or violence, and the organizational structure of the perpetrators. We are going to map the strict legal boundaries separating theft, robbery, and brigandage, relying directly on Supreme Court jurisprudence. Mastering this area of criminal law requires isolating the exact millisecond and the specific physical action that causes one crime to mutate into another. Solving bar exam fact patterns requires looking past the value of the property to analyze the specific mechanics of the offender's asportation. This root node represents the baseline parameters under Articles 293 and 308, taking personal property belonging to another, with intent to gain, and without the owner's consent. The jurisprudence defines the exact moment of consummation. In People v. Sobervilla, the Supreme Court established that asportation is complete the moment the offender gains physical possession, regardless of whether they have the opportunity to actually dispose of the item. A strict logistical exception exists for bulky goods stolen in guarded areas, seen in People v. Dino, the facility's security checkpoint. Contrast that with the theft of non-bulky goods in People v. Espiritu. When items can be easily concealed, freedom to dispose is assumed immediately, consummating the crime before the offender even attempts to exit the premises. If the taking lacks violence against persons or force upon things, the legal path shoots straight down and strictly defaults to theft under Article 308. This brings us to a specific anomaly, finder's theft, where taking occurs without an active removal of property from the original owner. The legal mechanism here was solidified in People v. Avila. A finder who picks up lost property and fails to deliver it to the authorities assumes physical possession, but not juridical possession. Retaining that found item with the intent to gain retroactively satisfies the legal element of taking. Theft serves as the baseline of unauthorized physical possession. It transforms into a felony the precise millisecond the offender's intent to gain solidifies. Moving across the matrix, we reach robbery. The trigger that mutates theft into robbery is the introduction of force or violence. This node instantly splits into two distinct typologies: violence or intimidation under Article 294, and force upon things under Articles 299 and 302. We need to isolate the force upon things track to correct a pervasive error in bar exam analysis. While breaking an object might involve physical force, the legal classification of force upon things only triggers when that force is used to enter a building. The ruling in People v. Adorno perfectly illustrates this structural boundary. In Adorno, the offender broke the glass of a commercial show window and reached his hand inside to extract 40 watches. The Supreme Court ruled this act as theft, not robbery. Because the offender merely introduced his hand and his body never physically entered the building, the structural entry requirement for force upon things failed. The code provides exactly one exception to the entry requirement. Robbery can occur without building entry if, and only if, a locked or sealed receptacle is broken inside the premises, or removed to be broken open outside. The force upon things classification penalizes the violation of a location's structural sanctity, rather than the simple destruction of property. Pivoting to the violence against persons track, we trace the matrix to its absolute extreme, the special complex crime of robbery with homicide. The statute binds these two acts with a highly specific phrase: the homicide must be committed by reason or on occasion of the robbery. This dictates a strict timeline requirement. The intent to rob, the animal lucrandi, must precede the killing. The jurisprudential limits of this complex crime are unyielding. The charge of robbery with homicide holds even if the person killed during the altercation is the robber himself. As demonstrated in People v. Mabasa, the charge holds even if the death supervenes by mere accident, so long as it occurs on the occasion of the robbery. The Supreme Court interprets this statute strictly to maximize the deterrent against violent property crimes, removing mitigating leniency for accidental deaths occurring during a heist. Conversely, if the homicide precedes the taking of property and the intent to game only arises as an afterthought, the complex crime fails. The acts remain legally separate charges of homicide and theft. The special complex crime fuses two independent felonies into an indivisible legal anomaly. The initial property intent permanently taints the resulting tragedy. The final multiplier we apply to this matrix is the organizational element of acting by a band under Article 296. The Penal Code sets a strict numerical statutory threshold for this multiplier to activate. Under the law, this group of 3 armed men mathematically fails to constitute a band. Article 296 explicitly requires a minimum of 4 armed individuals. When that 4-man threshold is met, we face the most critical organizational distinction in the syllabus, differentiating robbery and band from brigandage under Article 306. The distinction relies entirely on the parameters of the enterprise. In U.S. v. Feliciano, the court ruled that if 4 armed men conspire to execute a single specific robbery, the act is classified strictly as robbery and band. But if the group is organized for the general, continuing purpose of roaming the high maze to rob or kidnap, the nature of the crime mutates into brigandage. The evidentiary burden shifts heavily. Brigandage is consummated by the mere formation of the armed group for that illicit purpose, even if no actual highway robbery ever takes place. Robbery and band punishes the collaborative execution of a specific violent act. Brigandage punishes the very existence of an illicit enterprise. Looking at the completed decision tree, we can see the full conceptual architecture of property crimes under Title 10. By applying specific facts to the root node, you can trace the exact legal pathway, watching multipliers compound to dictate the final penalty. Criminal liability functions as a formula of compounding variables, where the market value of the item is often the least significant factor. You must interrogate the timeline. Did the intent to gain precede the violence, or follow it as an afterthought? You must interrogate the structure. Was the force applied strictly to the object, or was it used to breach a building? And you must interrogate the organization. Was the armed group formed for a specific hit, or a continuing illicit enterprise? Accuracy in the criminal law, the exact same physical act of taking property can trigger vastly different statutory penalties. The severity of the crime depends entirely on the means of execution and the character of the location. To understand these distinctions, we start at the statutory baseline for all crimes of subtraction, theft, under Article 308. This diagram illustrates the 4 pillars required to constitute theft. It requires the taking of personal property that belongs to another with intent to gain. Crucially, the taking must be without the owner's consent and without the use of violence, intimidation, or force. The core subjective element driving this definition is animus lucrandi, the intent to gain. Gain does not require actual financial profit. In the ruling of People v. Fernandez, taking another person's car for a joyride provides utility and pleasure. Under the law, that qualifies as gain. The courts expand this interpretation further. In People v. Padilla, an employee took documents to deliver to government investigators. The court ruled that the satisfaction of revenge, or the pleasure of seeing an employer harassed, fulfills the animus lucrandi requirement. Theft is rooted in the offender's subjective intent to derive utility, pleasure, or satisfaction from depriving another person of their property. To pinpoint when this crime is complete, we must discard the common law concept of asportation, which requires the offender to physically carry goods away. Look at this flowchart. Under the Revised Penal Code, theft is consummated the exact moment an offender gains physical control. As seen in People v. Sovervilla, abstracting a pocketbook in a crowded market instantly triggers a consummated status, even without carrying it away. Even if the thief is instantly caught by police and has zero opportunity to freely dispose of the item, the charge remains consummated theft, not frustrated theft. Keeping the charge isolated as simple theft requires an absolute negative constraint. There must be zero violence against persons or force upon things. The moment you add physical disruption to the environment or coercion against a human being, the legal framework shifts entirely. The baseline of theft relies on seamless, frictionless physical control. Introduce systemic friction, and the offense upgrades directly into the realm of robbery. The first major escalation from simple theft is robbery by force upon things, governed by Articles 299 and 302. Here we see the matrix branch outward from our baseline. Let's zoom in on branch A on the left, force upon things. The statute applies a strict test. Force upon things only qualifies as robbery if that force is used specifically to gain entry into a building. We can stress test this rule using the case of People v. Adorno. In Adorno, the offender broke the glass of a show window and reached inside to pull out several watches. The court ruled this is theft, not robbery, because the offender merely introduced his hand. His body never made an actual entry into the building. When a building is entered, the law splits further between an inhabited house under Article 299 and an uninhabited place under Article 302. If the place is uninhabited, the rules for force demand specific targets. The offender must break a door, wardrobe, chest, or a sealed receptacle for the act to qualify. This leads to a second stress test, People v. Puzan, which involved the destruction of a padlock on a garage door. The court held that breaking a detachable accessory gadget like a padlock without breaking the door itself fails the statutory test for force upon things. The charge reverts back to theft. The second escalation path is robbery with violence against or intimidation of persons under Article 294. Panning across the matrix to branch B, we encounter violence against persons. The defining mechanism here is timing. The violence or intimidation must occur before or during the act of gaining possession, the asportation. If the taking is already complete and the offender punches the victim merely to escape pursuit, the law treats the events as two distinct crimes, theft plus physical injuries. It is not robbery. At the peak of this branch sits the special complex crime, specifically robbery with homicide or robbery with rape. This timeline tracks the iter criminis, or the path of the crime. For a special complex crime to exist, the intent to gain marker must precede the act of violence on the timeline. If an offender commits a homicide specifically to eliminate an obstacle to stealing, the sequence fits. The charge is robbery with homicide. Conversely, if an offender commits a murder or rape and only takes the victim's property as an afterthought, the original intent to gain was absent. The acts remained separate, distinct crimes. Article 294 is absolute. Once the robbery commences, it remains robbery with homicide, even if the resulting death supervenes by mere accident. This absolute liability is so unyielding that the charge holds even if the person killed is one of the robbers themselves. In special complex crimes, the original animus lucrandi acts as a legal black hole. It possesses a gravitational pull that absorbs all resulting violence, whether intentional or accidental, into a single, indivisible offense. Stepping back from the individual act, the Penal Code multiplies liability when evaluating group dynamics and criminal syndicates. The statutory threshold that elevates a property crime into a group offense is the presence of 4 or more armed men. Zooming out completely, we apply a multipliers layer to our branches. The 4 or more armed men node splits into 2 distinct classifications: robbery in band and brigandage. Robbery in band, under Article 296, applies when the group's purpose is to commit a specific, predetermined robbery. In this scenario, the band operates as a qualifying or aggravating circumstance attached to that specific property crime. It introduces a strict vicarious liability rule. Any member present during the robbery is liable for any assault committed by the band, unless they can prove they attempted to prevent it. At the far extreme of the matrix, we find brigandage and highway robbery. Look at this map visualization. The overarching operational intent separates the two. On the left, specific targeted dots represent robbery in band. On the right, a highlighted highway shows a fluid, roaming zone of threat representing brigandage. Brigandage does not require a predetermined target. The organization's entire purpose is to roam and commit indiscriminate acts of depredation, kidnapping, or extortion on highways. The Supreme Court anchored this distinction in the People v. Puno doctrine. In Puno, the court ruled that a single act of robbery committed on a highway against a specific, predetermined victim is not highway robbery under Presidential Decree 532. It is standard robbery because it lacks the element of indiscriminate outlawry. Tracing the full decision tree of property crimes, we begin at the baseline of taking, scale upward based on the presence of physical boundaries or violence, and reach the peak through the overarching intent of an organized group. Philippine criminal jurisprudence scales liability based on the physical boundaries breached, the human cost incurred, and the systemic terror intended by the perpetrators, moving far beyond.
This video discusses who is guilty of robbery under Article 293 of the Revised Penal Code. Robbery is defined in Article 293 and is classified into 2 types: robbery with violence against or intimidation of persons, and robbery by the use of force upon things. Focusing on robbery by force upon things, there are 2 kinds: those committed in an inhabited house, public building, or edifice devoted to religious worship under Article 299, and those committed in an uninhabited place or a private building under Article 302. The elements of robbery generally require personal property belonging to another. Special classes of personal property, such as motor vehicles and large cattle, are also covered under specific articles of the Revised Penal Code and relevant special laws. Even prohibited articles can be the subject of robbery. Misappropriation of seized dangerous drugs or proceeds of crime by an apprehending officer is penalized under the Dangerous Drugs Act. The property must belong to another. However, an owner can be guilty of robbery of their own property if taken from a bailee with the intent to charge the bailee with its value. Another element is the unlawful taking of the property. The taking must be against the owner's will. If property was initially taken lawfully, but followed by unlawful misappropriation, the crime committed may be estafa or malversation, not robbery. Robbery is complete upon the gaining of possession in cases of violence or intimidation against persons, regardless of the opportunity to dispose of the property. For robbery with force upon things, the object must be taken out of the building to consummate the robbery. The taking must be with intent to gain, which is presumed from unlawful taking of personal property belonging to another. If intent to gain is absent, the crime committed may be grave coercion under Article 286. The final element involves violence against or intimidation of a person or force upon things. Violence must be against the person of the offended party, not merely upon the things taken. Intimidation includes causing fear, threats of arrest, or brandishing a weapon. Intimidation doesn't need to be a threat of bodily injury, such as threatening the closure of a store. It also does not need to be immediately followed by the taking. as long as the intimidation facilitates the eventual taking. The violence or intimidation is required to be present before the asportation is complete. Violence inflicted after asportation is complete may constitute a separate crime, such as theft and physical injuries or grave threats. Violence resulting in homicide, intentional mutilation, rape, or serious physical injuries under Article 263 makes the taking of personal property robbery complex with any of these crimes under Article 294. However, the use of force upon things does not constitute robbery if the culprit never entered the building. When violence or intimidation is used, the taking is always robbery, and the value of the property is immaterial. When force upon things is used, entry into the building is required, and the value of the property determines the penalty. If both elements concur, the offense is classified as robbery with violence against or intimidation of persons. Robbery with violence against or intimidation of persons is specifically addressed in Article 294. The penalties start with robbery with homicide under the first subdivision, which is defined as homicide committed by reason or on occasion of the robbery. For homicide to be deemed committed on occasion or by reason of robbery, the intent to take personal property must precede the killing. Homicide may precede robbery to eliminate an obstacle or occur after robbery to suppress evidence or facilitate escape. Robbery with homicide also includes instances where the person killed is the robber himself, or if death occurs merely by accident. The complex crime also applies when homicide coexists with rape in the commission of the robbery, or if homicide is not proven but robbery is. The crime of robbery with rape, defined under the second subdivision of Article 294, applies when rape accompanies the robbery. This includes rape committed on the occasion of the robbery, robbery with multiple rapes, and robbery with rape committed by two or more persons. Robbery with rape is still the offense, even if the rape occurred in a different place. For robbery with rape, the intent to take personal property with intent to gain must precede the rape. The rule changes when rape is committed before the taking of property. If property is taken after rape without intent to gain, it's not robbery. There is no robbery if there is only attempted rape. The complex crime also applies when rape coincides with homicide during the robbery. Furthermore, the information in a robbery with rape case must be signed by the fiscal. Other complex crimes under Article 294 include robbery with intentional mutilation and robbery accompanied by arson. The second subdivision of Article 294 covers robbery with serious physical injuries under Article 263, resulting in insanity, imbecility, impotency, or blindness. The third subdivision covers serious physical injuries under Article 263, resulting in the loss of use of speech, hearing, smell, or a major limb, or incapacity for habitual work. The fourth subdivision of Article 294 addresses robbery with unnecessary violence and intimidation, where the violence or intimidation is carried to a degree clearly unnecessary for the commission of the robbery. This is distinguished from cases where violence or intimidation is considered necessary. This subdivision also includes robbery with serious physical injuries under Article 263, subsections 3 and 4, which result in deformity, loss of a member, or illness or incapacity for work exceeding 30 days. The injuries must be inflicted on a person not responsible for the commission and in the course of execution of the robbery. The fifth subdivision of Article 294 addresses simple robbery, covering cases where only less serious or slight physical injuries are inflicted, or when the offender uses only intimidation. Violence or intimidation does not need to exist before or at the exact moment the object is taken. Intimidation involves acts against persons that, by their nature or circumstances of execution, inspire fear in the victims. The requirements for intimidation should be carefully noted. Article 294, except for the last subdivision, defines special complex crimes. It is also important to consider the liability of accessories without knowledge of the other crimes committed. Distinctions must also be made between robbery and threats to extort money, grave coercion, and bribery. This video examines robbery with physical injuries as defined in subdivisions 3, 4, and 5 of Article 294 of the Revised Penal Code when committed in an uninhabited place, by a band, or with the use of a firearm on a street or alley. The special complex crimes without further qualifying circumstances under Article 295 include robbery committed with homicide, rape, arson, and intentional mutilation or serious physical injuries leading to insanity, imbecility, impotency, or blindness. It is important to note that special complex crimes under Article 294, Subdivisions 1 and 2, are subject to ordinary aggravating circumstances under Article 14. This can lead to a maximum period of punishment if there is no offsetting ordinary mitigating circumstance. Additional offenses qualifying the penalty under Article 295 include being committed in an uninhabited place by a band or by attacking a moving train, streetcar, motor vehicle, or airship. The leader of a band is punishable with a penalty 1 degree higher than that for mere members. Other qualifying circumstances include entering a passenger's compartment of a conveyance and taking passengers by surprise. Robbery on a street, road, highway, or alley is also qualified if intimidation is made with the use of firearms. Qualifying circumstances in Article 295 must be alleged in the information. These qualifying circumstances cannot be offset by generic mitigating circumstances. Now let's look at the definition of a band and the penalty incurred by its members under Article 296. Robbery by a band under Article 296 requires at least 4 armed men to participate. Even clubs may constitute arms. Note that this article may still apply even if only 2 out of 4 malefactors were armed. The use of an unlicensed firearm in a robbery leads to the imposition of the maximum penalty for all malefactors, without prejudice to criminal liability for illegal possession of firearms. However, the special aggravating circumstance of using an unlicensed firearm is not applicable to robbery with homicide committed by a band. The use of a firearm, regardless of license status, qualifies a robbery defined under Article 294, Subdivisions 3, 4, and 5, when committed on a road, street, highway, or alley, applying the maximum of the maximum period of the proper penalty. Members of a band present during the commission of a robbery are punished as principals for any assaults committed by the band, unless they can prove they attempted to prevent the assault. The requisites for this liability include being a member of the band and being present during the robbery. The other members of the band must have committed an assault. The offender did not attempt to prevent the assault. Proof must be presented to escape liability. If the robbery was not committed by a band, a robber who did not participate in an assault is not liable for it. Similarly, in robbery with homicide not committed by a band, one who did not participate in the killing is liable for robbery only, if homicide was not predetermined during the plotting of the robbery. If there is a conspiracy to commit robbery with homicide, all conspirators, even fewer than 4 armed men, are liable for the special complex crime. Even if the conspiracy was for robbery only, if homicide occurs, all band members are liable for robbery with homicide. Proof of conspiracy is not necessary when 4 or more armed men commit a robbery. The crime of robbery with homicide in band does not exist. The indictable offense remains robbery with homicide, with the band as an ordinary aggravating circumstance. We will now discuss attempted and frustrated robbery with homicide under Article 297. This covers homicide committed by reason or on occasion of attempted or frustrated robbery. The penalty does not distinguish whether the robbery was attempted or frustrated. Frustrated robbery with homicide is another scenario. The penalty for robbery with homicide does not apply if the homicide itself merits a higher penalty, such as in cases of murder or parricide. In this context, homicide is understood in a generic sense. Attempted or frustrated robbery with homicide is a special complex crime. However, if the crime is attempted or frustrated robbery with serious physical injuries, it is considered an ordinary complex crime, applying Article 48. Only one crime of attempted or frustrated robbery with homicide is committed, even if slight physical injuries are also inflicted. Moving on to Article 298, the execution of deeds by means of violence or intimidation. The offender is held guilty of robbery and punished by the penalties prescribed for robbery with violence against or intimidation of persons. The elements include the offender's intent to defraud another and compelling the victim to sign, execute, or deliver a public instrument or document. Next is robbery in an inhabited house, public building, or edifice devoted to worship under Article 299. The penalty depends on the value of the property taken and whether the offender carried an arm. Robbery in an inhabited house is punished with a heavier penalty compared to that committed in an uninhabited place. The penalties differ for armed versus unarmed persons based on the value of the property not exceeding or exceeding 50,000 pesos. The use of a bolo by a servant to open a trunk in the master's house is considered by some to not be an arm in this context. Robbery committed in the dependencies of an inhabited house, public building, or edifice devoted to religious worship carries a lower penalty, 1 degree below those specified. Article 299 details modes of commission, including robbery with force upon things. The elements of robbery with force upon things under Article 299, Subdivision A, include entering an inhabited house, public building, or edifice devoted to religious worship. Entry must be effected through specified means for the purpose of entry, not to exit. The entry methods include entering through an opening not intended for entrance or egress, breaking a wall, roof, floor, door, or window, using false keys, picklocks, or similar tools, or using a fictitious name, or pretending to exercise public authority. Once inside, the offender must take personal property belonging to another with intent to gain. Key requisites are that the offender must enter the house or building with the intention of taking property, and the place entered must be an inhabited house, public building, or edifice devoted to religious worship. Robbery with force upon things under Article 299, Subdivision B, applies when the offender is already inside the dwelling house, public building, or edifice devoted to religious worship, regardless of how they entered. The means of entry specified in Subdivision A are not required for this subdivision. Subdivision B also covers taking furniture or objects away to be broken or forced open outside the place of robbery. Breaking the keyhole of a wardrobe is considered breaking locked furniture. For sealed receptacles taken out, actual breaking outside is not necessary. We continue our discussion with robbery in an uninhabited place and by a band under Article 300 of the Revised Penal Code. The penalty for this type of robbery is increased due to the presence of qualifying circumstances. Note that both being in an uninhabited place and by a band must concur to be considered a qualifying circumstance. It is crucial that the qualifying circumstance of an uninhabited place and by a band must be alleged in the information. This section also distinguishes between qualified robbery with force upon things under Article 299 and qualified robbery with violence or intimidation of persons under Article 295. Next, we define what constitutes an inhabited house, public building, or building dedicated to religious worship, including their dependencies, under Article 301. An inhabited house is defined as a shelter, ship, or vessel that serves as a dwelling, even if the inhabitants are temporarily absent when the robbery is committed. Dependencies, as defined in Article 301, first paragraph, include interior courts, corrals, warehouses, and other enclosed places contiguous to the building with an interior entrance. Orchards and other lands used for cultivation are not considered dependencies. For a space to be a dependency, it must be contiguous to the building. For a dependency to exist, it must have an interior entrance connected with the building and form part of the whole structure. A public building, defined in Article 301, third paragraph, includes buildings owned by the government or private persons, but used or rented by the government, even if temporarily unoccupied. Now, let's examine robbery in an uninhabited place or in a private building, covered under Article 302. Taking mail matter or large cattle qualifies the robbery. This is considered a qualified robbery, since the penalty is 1 degree higher when the object of the robbery is mail matter or large cattle. The elements of this robbery require the offender to enter an uninhabited place, or a private building not used for dwelling, public, or religious purposes. Uninhabited place in this context refers to an uninhabited building, as confirmed by jurisprudence and the Spanish text meaning of despoblado. A quote, well mentioned in the first paragraph of Article 299 feet refers to structures that are not inhabited houses, public buildings, or places of religious worship. A quote building includes any structure used for storing or safekeeping property, but a pigsty is not considered a building. The commission of the crime must also be attended by circumstances specified in Article 302, such as entrance through an opening not intended for entry, breaking a wall, roof, floor, door, or window, or using false keys or similar tools. Additional circumstances include breaking a door, wardrobe, chest, or sealed furniture or receptacle. Furthermore, the removal of a closed or sealed receptacle, even if broken open elsewhere, also qualifies the offense under Article 302. Unnailing a cloth over a door or breaking a padlock can be considered force upon things. However, if only a detachable accessory gadget like a padlock is broken, and not the door or lock itself, the crime may be considered theft rather than robbery with force upon things. The receptacle broken must be closed or sealed, not merely locked or sealed as under Article 299. The breaking of the receptacle is required to constitute robbery. Furthermore, the mere removal of a closed or sealed receptacle is insufficient. The minimum requirement is the intention to open it by force. The use of a fictitious name, or pretending to exercise public authority, is not provided in Article 302 as a circumstance to aggravate the penalty for this type of robbery, because there is no one to deceive in an uninhabited place. Finally, the offender must have taken personal property belonging to another with intent to gain. Robbery in a store is punishable under Article 302 or Article 299, depending on whether the store is used as a dwelling or not. Under Article 299, the store is considered an inhabited house if used as a dwelling or connected to the owner's house by an interior entrance. Our final topic is robbery of cereals, fruits, or firewood in an uninhabited place or private building under Article 303. The penalty is 1 degree lower than that prescribed under Articles 299 and 302. Cereals include seedlings and, quote, pallay or unhulled rice, but not hulled rice, which is not an immediate product of the soil. The Court of Appeals held that cereals must be kept as, quote, seedling or taken by the robber for that purpose, a view rejected by the Supreme Court. The reason for rejection is that it leads to an unfruitful inquiry into the intent of the robber and the owner, a requirement not explicitly stated in the law. A special mitigating circumstance applies only in cases enumerated in Articles 299 and 302, limiting it to robbery with force upon things. It does not extend to robbery with violence or intimidation of persons, which is punishable under Article 294. We now examine the penalty for illegal possession of picklocks and similar tools under Article 304. The penalty applies to the possessor and the maker of picklocks or similar tools who is not a locksmith. The same penalty applies to a locksmith who is the offender. The elements of this crime require the offender to possess picklocks or similar tools specially adopted for robbery and without lawful cause. Actual use of the tools is not necessary. Possession of genuine keys stolen from the owner or keys other than those intended for the lock is not punishable in itself. Next is the discussion on false keys, defined under Article 305. False keys include picklocks or similar tools adapted to commit robbery and genuine keys stolen from the owner. Genuine keys entrusted by the owner do not fall under the term false key. We now turn to brigandage, defined in Article 306, which also specifies the penalty. The elements of brigandage require at least 4 armed persons forming a band of robbers. The arms may be any deadly weapon, not necessarily firearms. Mere membership in an armed band is insufficient for brigandage. Evidence must show the band was organized for the purposes enumerated in Article 306. If any member carries unlicensed firearms, all are presumed to be highway robbers or brigands, and the penalty is imposed in its maximum period. A presumption of brigandage arises if the accused are members of a lawless band possessing unlicensed firearms. The purpose of the band must be one of the following: to commit robbery on a highway, kidnap for extortion or ransom, or attain any other purpose by force and violence. The term highway includes city streets. Previous activities of the band can be considered to determine the purpose of brigandage. The purpose must be one of those enumerated in Article 306. The object of the law in punishing brigandage is to prevent the formation of a band of robbers, so such formation is sufficient for violation of the law. Conviction requires that an organization of more than 3 armed persons forms a band of robbers. The purpose of the band must be one of those listed in Article 306. Furthermore, the band must have gone upon the highway or roamed the country for that purpose, and the accused must be a member of the band. Brigandage is distinguished from robbery in band. If the purpose is to commit only a particular robbery, the offense is robbery in band, not brigandage. In brigandage, mere formation for the mentioned purposes is sufficient, while in robbery, actual commission must be proven. We continue our discussion on highway robbery or brigandage under Presidential Decree No. 532. The first type involves the seizure of a person for ransom, extortion, or other unlawful purposes on a Philippine highway. The elements include: a person is seized by the offender, and the seizure is for unlawful purposes like ransom or extortion. The third element is that the seizure must be committed on any Philippine highway. This refers to roads, streets, passages, highways and bridges, or railways or railroads within the Philippines. This includes areas used by persons, vehicles, locomotives, or trains for movement or transportation of goods and property. Let's review the penalties for highway robbery or brigandage. Simple highway robbery is penalized with reclusion temporal minimum. If it includes physical injuries or other crimes committed on the occasion of the robbery, the penalty is reclusion temporal, medium, and maximum. The second type is the taking away of property by violence, intimidation, or force upon things, committed on any Philippine highway. It is critical that acts constituting highway robbery or brigandage under Pres. Dec. Number 532 must be committed indiscriminately. A single act of robbery on a highway does not constitute highway robbery or brigandage under this decree. Pres. Dec. Number 532 aims to repeal or modify certain provisions of the Revised Penal Code, specifically affecting Article 306. It punishes only acts of robbery perpetrated indiscriminately against any person on Philippine highways, not those committed against a predetermined or particular victim. Next, we discuss aiding and abetting a band of brigands under Article 307 of the Revised Penal Code. The elements are, there is a band of brigands, and the offender knows this. Also, the offender does any of the acts specified in Article 307 and is presumed to have performed them knowingly. The acts specified in Article 307 include aiding, abetting, or protecting the band of brigands, giving them information on the movements of peace officers, or acquiring or receiving property taken by them. We now examine aiding or protecting highway robbers, or abetting the commission of highway robbery or brigandage under Pres. Dec. Number 532. The offender is considered an accomplice and is punished 1 degree lower. This includes knowingly aiding or protecting highway robbers, and is presumed to be done knowingly unless proven otherwise. Aiding or protecting highway robbers also involves directly or indirectly abetting the commission of highway robbery or brigandage. These acts are presumed to have been performed knowingly, unless the contrary is proven. Pres. Dec. Number 532 seeks to repeal or modify pertinent provisions of the Revised Penal Code, affecting Article 307. Now we turn to the liability for theft under Article 308 of the Revised Penal Code. Ordinary theft is defined as taking personal property of another, with intent of gain, without violence or intimidation of person or force upon things, and without the owner's consent. Special forms of theft include failing to deliver lost property to authorities or the owner. Lost property is generic and includes property lost through stealing or other acts. Proof is required to establish the time of seizure of the thing. A finder under Article 308, Subdivision 1, is not limited to an actual finder but may be a finder in law as long as the property was lost. The elements continue. The object must be lost property belonging to another. Knowledge of the owner that the property was lost is not required. What matters is that the accused knew or had reason to know the property was lost. Finally, the accused must have had the opportunity to return or deliver the lost property to the owner or local authorities. The fourth element is that the accused refrained from returning or delivering the lost property. Intent to gain is inferred from the deliberate failure to deliver lost property to the proper person, as the finder knows the property does not belong to them. However, delay in delivery is immaterial if the finder eventually surrenders it voluntarily to the owner. Other special forms of theft include removing or making use of fruits or objects of damage maliciously caused to the property of another. Another form is hunting, fishing, or gathering forest products after entering an enclosed estate or field where trespass is forbidden without the owner's consent. The elements for this specific type of theft include an enclosed estate or field belonging to another where trespass is forbidden, the offender enters it, and the offender hunts, fishes, or gathers products therefrom without the owner's consent. Note that fishing should not be in a fish pond or fishery within the field, otherwise it is qualified theft. We now discuss the elements of ordinary theft under Article 308 of the Revised Penal Code. One element is the taking of personal property. Taking away or carrying away the thing is not always required for consummation. Theft is consummated upon the voluntary and malicious taking realized by the material occupation of the thing. Regarding the consummation of theft, especially where the place is surrounded by a fence or wall, the Supreme Court has rejected the doctrine that free disposition determines whether the crime of theft has been committed. The court concluded there can be no crime of theft in the frustrated stage, as taking is complete upon the offender gaining possession. Theft of other goods, like hospital linen, is considered consummated once the offender has removed and taken possession of the items, even if discovered later at a checkpoint. In theft of non-bulky goods, freedom to dispose of the item is palpably less restricted. The element of intent to gain does not require a character of permanency in withholding the property. However, the offender must have the intention to make themselves the owner of the thing taken, meaning placing the property under their control as their own. Taking can occur even if the offender initially received the thing from the owner, as long as a subsequent act results in unlawful taking or asportation, like appropriating a gold bar meant for examination. However, there is no theft if there is no taking of personal property, such as when a husband pawns his wife's property in his lawful possession. Personal property, as an element of theft, includes electricity, gas, promissory notes, checks, and commercial invoices. The business of providing telecommunication and the telephone service provided are also personal property under Article 308, and unauthorized routing of calls is considered an act of subtraction. A key point is that if the personal property stolen consisted of worthless checks, the theft committed is punishable only as an impossible crime because the object was without value. The property must belong to another. If a person takes their own property, even if pledged to another, they are not guilty of theft. Selling a share of a partner or co-owner is not considered theft, as long as the property is jointly owned. Property not yet delivered, such as separation pay, is not yet considered the property of the employee, meaning it is not the property of another for the purpose of theft. This also applies to goods not yet weighed or measured when the transfer of ownership has not been effected. The taking must be done with intent to gain, which is presumed from the unlawful taking. Good faith is a defense. Taking property believed to be one's own is not theft. Gain includes benefiting oneself or another, even if it is simply deriving utility, satisfaction, enjoyment, or pleasure from the use of the things. Using another's car for a joyride or to learn driving is considered sufficient gain, encompassing satisfaction and pleasure. Giving stolen goods to another is also considered theft, as the satisfaction derived is real gain. Actual or real gain is not necessary. The desire or intent to gain is sufficient. However, intent to gain does not include motivations like revenge, where the intention is to satisfy hate or vengeance rather than greed. The taking must occur without the owner's consent. Consent must be freely given, not merely inferred from a lack of opposition. A lack of consent is an indispensable allegation in a charge of ordinary theft. It is presumed that an owner would not consent to the taking of property without consideration. There is no theft when the taking is with the owner's consent or acquiescence. The identity of the owner is not always required, but the lack of consent is crucial. Finally, theft does not require that the taking be against the will of the owner, only that it is without their consent. Unlike robbery, theft must also be accomplished without the use of violence, intimidation against persons, or force upon things. The taking of property without violence or intimidation of persons, even if violence is used later, is still theft, as the taking was complete before the violence was employed. Similarly, violence entirely separate from the act of taking, such as tying up a victim hours before taking their money, constitutes theft. Theft is committed without force upon things when gaining entry into a building. If force is used on a corral, which is not considered a building or its dependency, the crime remains theft. Robbery only applies if force upon things is used to enter a building or dependency. Possession of recently stolen property raises a presumption of theft of all the goods if they were lost at the same time and place. This presumption does not apply to the piece-by-piece disappearance of goods at different times if only part is found with the accused. Theft is distinguished from robbery by the absence of violence or intimidation of persons or force upon things. For example, taking roosters from a coop in a yard without violence is theft, not robbery, especially if the coop is not considered a dependency of an inhabited house. Theft is generally not considered a continuing offense in the Philippines. The crime is consummated upon the taking, regardless of subsequent movement. However, the intent to deprive the owner of possession can lead to liability for the value of the whole stolen object, even if only a part is ultimately taken away. We continue to discuss the penalties for theft under Article 309 of the Revised Penal Code, specifically focusing on the basis of the penalty, the value of the stolen item. Higher values, such as more than 2,200,000 pesos, result in more severe penalties, starting with prison mayor maximum. Penalties continue to be scaled down based on the value of the property stolen. For instance, if the value is not exceeding 500 pesos, the penalty is arresto mayor in its minimum and medium periods. Special considerations apply when there is no evidence of the value of the property taken. The video also covers penalties based on the value and nature of the property taken in some cases. When theft is committed under circumstances outlined in Article 308 and the value does not exceed 500 pesos, the penalty is arresto menor or a fine. The penalty may be mitigated if the offender acted under the impulse of hunger or poverty and the value stolen does not exceed 500 pesos. Additionally, judicial interpretations guide penalty imposition when no medium period exists for an accessory in theft. We now discuss qualified theft under Article 310, which imposes a penalty 2 degrees higher than those specified in Article 309. One qualifying circumstance is theft committed by a domestic servant. This circumstance always qualifies the theft. Theft committed by a housemate or a laborer is generally not automatically qualified theft. This depends on whether a grave abuse of confidence or a relation of intimacy and trust, as required by law, exists. Theft is qualified when committed by a truck driver of a truckload, or a shepherd of sheep under his care, or other persons with entrusted access, where a grave abuse of confidence is present. Theft committed with grave abuse of confidence is another qualifying circumstance. The abuse of confidence must be proven to be, quote, stemming from a relationship of dependence, guardianship, or vigilance between the offender and the victim. Grave abuse of confidence does not need to be premeditated. Mere presence at the time of the theft may be sufficient. However, if there is no proof of special confidence, qualified theft does not apply, such as when an employee takes advantage of their position but was not entrusted with the stolen item. Theft is also qualified if the property stolen is a motor vehicle, as specified in Article 310. However, the scope of Article 310 regarding motor vehicles has been narrowed by the anti-kidnapping law, excluding certain agricultural and specialized vehicles. If the purpose of taking a car is to destroy it by burning, the crime is arson, not qualified theft or malicious mischief. Regarding theft of a motor vehicle by the person who received it, it is qualified theft under the quote boundary system, but could be estafa if under a lease agreement. The theft of a motor vehicle is also penalized as, quote, carnapping under Republic Act No. 10,883, the new Anti-Carnapping Act of 2016. Theft under Article 309-310 now applies only to vehicles accepted from the anti-carnapping law's definition of motor vehicle. The elements of carnapping include taking a motor vehicle belonging to another without the owner's consent, or by means of violence or intimidation against persons, or by using force upon things with intent of gain. The penalty for carnapping is determined by the circumstances. The value of the stolen vehicle is immaterial. Carnapping committed without violence or intimidation is penalized as theft. If committed with violence or intimidation, it is penalized as robbery. Carnapping is complexed with homicide or rape if the owner, driver, or occupant is killed or raped during the commission of the crime, leading to life imprisonment. If the killing is not causally connected to the carnapping, lesser sentences apply. Qualified theft also includes theft of mail matter. This applies when an offender is a clerk in charge of the registry section taking a valuable package, as well as a private individual taking a letter containing a postal money order. The property stolen must be mail matter. However, if a postmaster to whom a registered letter containing a postal money order was delivered opens it and abstracts the money order, the crime is faithlessness in the custody of documents, not qualified theft. Qualified theft also covers the theft of large cattle. For theft of large cattle to be qualified, the animal must be taken alive. Killing a cow and taking its meat is considered simple theft. If the animal is killed out of hatred or revenge, the crime may be malicious mischief. Borrowers who sell the cattle they received may be liable for estafa, not qualified theft. A herdsman slaughtering a carabao under his care and taking its meat is guilty of qualified theft. Taking several cows simultaneously, even if belonging to different owners, is considered only one crime of qualified theft. Cattle rustling is penalized separately under the Anti-Cattle Rustling Law of 1974. The elements of cattle rustling include animals classified as large cattle. The act requires taking away by any means. It is not essential for the taking away to be for profit or gain, or with violence, although these circumstances affect the penalty. The value of the large cattle is immaterial. The penalty for cattle rustling is categorized based on circumstances. Simple cattle rustling without violence, intimidation, or force upon things carries a specific penalty. Heavier penalties apply when violence or intimidation is used, or when a person is seriously injured or killed as a result. Additional penalties are imposed if the offender is a government official or an alien. Presidential Decree No. 533, which addresses cattle rustling, sought to repeal or modify Articles 309 and 310 of the Revised Penal Code where inconsistent. Theft of coconuts taken from the premises of a plantation is qualified theft, reflecting the law's intent to protect the coconut industry. This applies whether the coconuts are still on the tree or on the ground within the plantation premises. If coconuts are stolen from a place other than the plantation premises, such as a pile in front of a house along a highway, the crime is only simple theft. Theft is also qualified for fish taken from a fish pond or fishery. The term fish in this context includes various aquatic animals like crabs, prawns, and shellfish. The theft is qualified when taken from a fish pond or fishery, which includes a fish corral. Fishing with explosives, poisonous substances, or electricity is penalized under a separate decree. Theft is qualified when committed on the occasion of specific calamities or disturbances, such as fire, earthquake, typhoon, volcanic eruption, vehicular accident, or civil disturbance. These situations allow for increased penalties due to the opportunistic nature of the crime. Special penal statutes also qualify certain types of theft based on the object involved. This includes the theft of materials, spare parts, products, or articles by employees, which carries heavier punishment under Presidential Decree No. 133. The theft of gold, known as high grading, is subject to severe penalties under Presidential Decree No. 581. High grading involves the unauthorized taking, removing, collecting, or processing of gold-bearing ores or rocks from a mining claim or camp. Penalties for high grading are scaled by the stage of execution, consummated, frustrated, or attempted. The penalties imposed are without prejudice to higher penalties under Article 309 if the value of the stolen goods warrants it. The penalty for high grading is higher if the offender is an employee or laborer of the mining claim operator. Unauthorized possession of gold-bearing materials is prima facie evidence of theft. Accessories who knowingly buy stolen gold are also penalized. The Philippine Mining Act of 1995, or Republic Act No. 7942, expanded mining-related offenses, defining the crime of theft of minerals. This includes extracting or disposing of minerals without agreement, or stealing ores or products from mines or processing plants. Using tampered water or electrical meters to steal water or electricity is subject to severe penalties. While PD 401 penalized this, Republic Act No. 7832 now penalizes electricity pilferage and theft of electric power lines/materials, expressly repealing related parts of PD 401. Theft of electricity can occur even without illegal installations, through methods like turning back meter dials, fixing the meter to under-register consumption, or tightening screws to slow rotation, as noted in the People v. Rolova case. Employees or officers of utility companies who connive with others to violate PD 401 regarding meter tampering or electricity theft are also liable. Additionally, timber smuggling or illegal cutting of forest products is punished as qualified theft under Presidential Decree No. 330. PD 330 was superseded by Section 77 of Presidential Decree No. 705, which, as amended, penalizes the unauthorized cutting, gathering, or possession of timber or other forest products. These violations continue to be treated as qualified theft. Moving to the anti-fencing law, Presidential Decree No. 1612, a quote, fence is any person or entity who commits the act of fencing. Individuals failing to secure clearance to sell second-hand articles are also punished as fences. The elements of fencing include dealing with an item of value that the offender knows, or should have known, was derived from the proceeds of theft or robbery. The offender must buy, receive, possess, sell, or dispose of the item, with intent to gain for themselves or another. We now examine the crime of theft of property from the National Library and National Museum, as stated in Article 311 of the Revised Penal Code. The penalty is fixed, regardless of the property's value. However, qualifying circumstances under Article 310 may increase the penalty. Next, we discuss the occupation of real property or usurpation of real rights in property under Article 312 of the Revised Penal Code. The penalty is a fine only, based on the gain obtained, or a fixed fine if the value cannot be ascertained. This crime involves taking possession of real property through violence or intimidation of persons. The elements of this crime include the offender taking possession of real property belonging to another. Violence or intimidation against persons must be used in occupying the property. The real property must belong to another, and there must be an intent to gain. Usurping real rights in property belonging to another also falls under Article 312. This involves the offender usurping real rights in property, and those real rights belonging to another. This must be done by means of violence or intimidation of persons. Violence or intimidation must be the means used in occupying real property or usurping real rights. If violence or intimidation occurred after entry or usurpation, Article 312 is not applicable. The offender must also have the intent to gain from the usurpation. A criminal action for usurpation of real property is not a bar to a civil action for forcible entry, as the causes of action are different. Occupation of real property or usurpation of real rights differs from robbery or theft, as the former involves real property or real rights, while the latter involves personal property. Republic Act No. 947 punishes entering or occupying public agricultural land, including public lands granted to private individuals. This act and Article 312 of the Revised Penal Code are distinguished by the object of entry and the modes of commission. Presidential Decree No. 772, although repealed, punished squatting in urban communities. However, squatting on public agricultural lands, such as grazing lands in rural areas, is punished under Republic Act No. 947. Altering boundaries or landmarks, under Article 313 of the Revised Penal Code, also deals with crimes against property. The crime's elements are the existence of boundary marks or monuments, and the offender altering these marks. Altering has a broad and indefinite meaning. Under Article 313, the intent to gain is not explicitly required. Mere alteration of boundary marks is punishable. While fraudulent intent is not necessary for the crime, felonious intent to usurp realty must be established as a moral element to apply the penalty. Fraudulent insolvency, under Article 314 of the Revised Penal Code, is another crime against property. The elements include the offender being a debtor with due and payable obligations, and the offender absconding with his property. Abscond does not require physically concealing the property. The third element of fraudulent insolvency is that the offender's creditors are prejudiced. Actual prejudice is required, not merely the intention to prejudice. Furthermore, this crime requires malice, which involves the intent to defraud the creditors. The person prejudiced in fraudulent insolvency must be the offender's creditor. Being a merchant is not an element of the crime, but it raises the penalty. Fraudulent insolvency is distinguished from a violation of the insolvency law, which requires the criminal act to have occurred after the institution of insolvency proceedings. We now cover swindling or estafa under Article 315 of the Revised Penal Code. This includes penalties for swindling, specifically under Presidential Decrees 1689 and 818, which cover crimes against property like misappropriation of funds from financial associations and false pretenses or fraudulent acts. The elements of estafa generally require the offender to defraud another through means specified in the Revised Penal Code, which can be achieved through abuse of confidence. In estafa with abuse of confidence, deceit is not an essential requisite. Another way estafa is committed is by means of deceit, which includes estafa by means of false pretenses or fraudulent acts, and estafa through fraudulent means. The elements of estafa by means of deceit include a false pretense, fraudulent act, or means, which must be made prior to or simultaneously with the commission of the fraud. Mere non-performance is insufficient to prove falsity, resulting only in civil liability. Further elements require the offended party to have relied on the false pretense or fraudulent means, inducing them to part with their property. Consequently, the offended party must have suffered damage. Fraud must be proven with clear and positive evidence. Deceit and abuse of confidence may coexist, meaning estafa can be committed through either means. However, if there is neither deceit nor abuse of confidence, there is no estafa even if damage occurs, leading only to civil liability. It is important to note that a conviction for estafa with abuse of confidence cannot be based on an information charging estafa by means of deceit, as they have different elements. Damage or prejudice capable of pecuniary estimation is required, as it forms the basis of the penalty. Damage or prejudice must be capable of pecuniary estimation and can involve the offended party being deprived of money or property. It also includes the disturbance of a property right, such as the sale of a rented item, which does not negate or diminish estafa liability. Subsequent payment after the commission of estafa does not extinguish criminal liability or reduce the penalty. Furthermore, the crime of estafa is not obliterated by the acceptance of a promissory note. Temporary prejudice can still constitute estafa, as demonstrated when an accused had possession of a check, preventing the offended party from disposing of the amount. However, full settlement of a loan procured by deceit within the agreed period may not constitute estafa. The modes of committing estafa with unfaithfulness or abuse of confidence include altering the substance, quantity, or quality of anything of value that the offender is obliged to deliver, even if the obligation is based on an immoral or illegal consideration. The elements for this mode require the offender to have an onerous obligation to deliver something of value. This obligation must be, quote, by virtue of an onerous obligation to do so. No liability for estafa exists if there is no damage caused. Altering the quality results in damage equivalent to the difference in value. However, if there was no agreement on quality, delivery of a subpar item is not estafa. Importantly, the obligation to deliver may be based on immoral or illegal considerations. Another mode involves misappropriating or converting money, goods, or other personal property received in trust, on commission, for administration, or under any other obligation to deliver or return the same. This includes denying having received the property. A check is included in money for the purpose of estafa, since its delivery creates a fiduciary relationship. The offender must receive the property. If it is taken without consent, the crime may be theft, not estafa. Money, goods, or personal property must be received under transactions transferring juridical possession, such as in trust, on commission, or for administration, with the duty to deliver or return the same. Juridical possession gives the transferee rights over the thing, even against the owner. Unless delivery transfers juridical possession, possession and title remain with the owner. Examples of things received in trust, leading to estafa if misappropriated, include proceeds from the sale of goods covered by a trust receipt, or a tenant appropriating their landlord's share of proceeds. Presidential Decree 155 also regards failure of an entrustee to turn over sale proceeds or return goods covered by a trust receipt as estafa. Property received on commission, with the duty to deliver the specific amount to a third party, results in estafa if spent by the offender. Receiving money for administration, where an offender fails to account for or turn over amounts upon demand, constitutes estafa. The obligation to deliver or return the same thing includes quasi-contracts and certain bailments, where the person receiving acquires juridical possession. Receiving property under a contract of bailment, like a deposit or loan for use, requires the return of the same thing. Examples include a stock certificate received as a deposit or a borrowed item to be returned. Misappropriation in these cases is estafa. The obligation to return or deliver the thing must be contractual, without transferring ownership to the accused. If ownership is transferred, as in a loan of money or a contract of purchase and sale, failure to pay is only a civil liability, not estafa. When ownership of the received item is transferred, failure to return it only incurs civil liability. This applies to advance or part payments in a sale, as ownership of the money passes to the seller, meaning refusal to return is not estafa. In sale or return agreements, retention converts the transaction to a sale, and ownership passes to the buyer. Therefore, retaining the object of the sale, or a subsequent sale by the buyer, is not estafa. Amounts paid to schools, such as, quote, breakage deposits, are not legal deposits. Ownership passes to the school. Likewise, in a sale on credit, failure to pay or return articles is not estafa, as ownership is transferred. If money or personal property is received as a loan, with no specific obligation to return the exact same item or use it for a particular purpose, the failure to return it is not estafa. Novation of a contract does not automatically affect criminal liability for estafa if the crime has already been committed. The criminal liability for misappropriation is incurred before the novation attempt. However, if a contract of agency is novated to one of sale or loan before a criminal complaint is filed, it may relieve the defendant of incipient criminal liability, as the obligation is converted to a civil one. Estafa is committed through the misappropriation or conversion of money or property, or the denial of its receipt. Misappropriation involves using company funds for personal purposes, even if temporarily, as the law makes no distinction between permanent and temporary acts. Momentary use of funds by an agent is not automatically estafa. Fraudulent intent is necessary. Conversion involves devoting the property to a use different from the agreement, such as pledging deposited property or property received for sale on commission. Conversion means the thing has been devoted to a use different from the one agreed upon. For instance, delivery of property to a subagent for the same purpose is not conversion unless explicitly forbidden. Withholding money received by an agent in good faith for self-protection against the principal in civil controversies is not estafa. The good or bad faith of the accused in withholding the money is the primary consideration. However, an agent cannot deduct a commission from collected amounts unless authorized, as the right to a commission does not make the agent a joint owner. Estafa is also committed by denying that the thing entrusted was received. The misappropriation, conversion, or denial of receipt must be to the prejudice of another. Gain on the part of the offender is not required, and prejudice does not necessarily refer only to the owner of the thing. A partner may be guilty of estafa if they misappropriate money or property received for a specific partnership purpose. A co-owner can be liable for estafa only if they misappropriate the thing after the termination of the co-ownership through partition. The fourth element is that demand is made by the offended party to the offender. Demand is not necessary when there is already evidence of misappropriation of goods, but it is typically required when the transaction starts as lawful. Demand is not legally required but is necessary, because failure to account upon demand is circumstantial evidence of misappropriation. However, the presumption of misappropriation arises only when the accused's explanation is absolutely devoid of merit. Demand cannot be dispensed with, even if the offender cannot be located, or if there was a specified time for delivery or return, as per constant Supreme Court doctrine. However, some court rulings suggest that prior demand is not necessary if the offender is in hiding or if the receipt itself stipulates an accounting date. Whether or not the obligation to return is guaranteed by bond is immaterial, as the undertaking refers only to civil liability. Estafa by misappropriation is distinguished from malversation by the requirement that in estafa, the offender obtains profit or gain personally. Estafa by misappropriation or conversion cannot be committed by mere negligence. For instance, an accused is not guilty of estafa if they negligently entrust money to business companions who then abscond with it. If a public officer accountable for funds is acquitted of malversation, private individuals allegedly in conspiracy may still be held liable for estafa through falsification of public documents. Misappropriation of a firearm received by a policeman, if not involved in a crime, is estafa. Apprehending officers who misappropriate seized dangerous drugs or instruments of crime are penalized under the Comprehensive Dangerous Drugs Act of 2002. A policeman having custody of a seized firearm without a permit to possess is guilty of malversation for its disappearance. Officers who misappropriate seized dangerous drugs are subject to severe penalties, including life imprisonment to death and perpetual disqualification from public office. Estafa by conversion is distinguished from theft. In theft, the offender takes the thing. In estafa, the offender receives the thing from the offended party in a manner that transfers juridical possession to the offender. The test to distinguish estafa from theft is that in theft, upon delivery, the owner expects the immediate return of the thing. If there is no transfer of juridical possession to the accused, the crime is theft. We continue our discussion about the elements of swindling, or estafa, under Article 315 of the Revised Penal Code. It is estafa when the property owner does not expect the immediate return of the item delivered to the accused, and the accused misappropriates it. However, if a servant receives property with an obligation to deliver it to a third person and misuses it, this is qualified theft, not estafa, as juridical possession remains with the owner. The conversion by a mere custodian is considered theft. Selling a thing received with instructions to pledge it for the owner's benefit constitutes theft if the intent to appropriate existed upon receipt. The gravity of the estafa offense is based on the amount not returned before the criminal action is filed. Estafa can be committed by taking undue advantage of a signed blank document to the prejudice of the offended party. The elements include the paper being blank and bearing the offended party's signature. The elements continue. The offended party must have delivered the paper. a document must be written above the signature without authority, and the resulting document must create a liability or cause damage to the offended party or a third person. We now cover the modes of committing estafa by means of deceit. This includes using a fictitious name or falsely pretending to possess power, influence, qualifications, property, credit, agency, business, or imaginary transactions. Deceit must be the very cause that induced the offended party to part with the thing. There are 3 ways of committing estafa under Article 315, Number 2. These include using a fictitious name, such as redeeming a pawn ticket under another person's name, or estafa by false pretense. The pretense must be false. Mere non-performance is insufficient. Estafa by false pretense can involve falsely claiming power, such as pretending to possess power to create money or discover hidden treasures, to induce the offended party to part with money. Estafa can also involve false claims of influence, such as falsely representing oneself as legally qualified to represent a party to obtain title deeds. Another false pretense category is misrepresenting one's qualifications. False pretense related to property involves pretending to have sufficient funds to pay for materials upon delivery when, in reality, the accused has no money. It also includes pretending to possess goods for sale and absconding with the money received. Regarding credit, estafa involves falsely pretending to be merchants with means to pay for ordered goods, only to disappear with the items received on credit. In terms of agency, it includes falsely claiming to be sent by a depositor to retrieve goods and converting them for personal use. Estafa by imaginary transaction involves falsely claiming to be engaged in a profitable business to secure money. Other similar deceits include presenting a fraudulent deed of donation to obtain a certificate of title. Estafa by deceit is distinguished from theft by whether the offender gained only material possession or both juridical and physical possession of the thing. If a salesman misappropriates retrieved machines, it is theft. Estafa and theft can form a complex crime, such as taking pawnshop tickets without consent and using them with a fictitious name. Estafa through falsification involves counterfeiting or imitating signatures on official documents and selling them. However, withdrawing money after stealing a passbook and forging a signature is sometimes held to be theft, as the false representation is a consequence of the theft already committed. Estafa through false pretense made in writing is a simple crime of estafa, not a complex crime through falsification. For example, cashing pension checks based on a false claim of being an unmarried widow. Attempted estafa through forgery occurs when the forgery is noticed upon presentation for cashing. Estafa can be committed by pretending to have bribed a government employee. This is without prejudice to any action for calumny. The elements include the offender asking money from the offended party and the offended party being induced to part with money as a bribe. The offender falsely represents that the money is for bribing a government employee. The offender intends to convert the money for personal use. For instance, pretending to bribe a doctor to declare someone unfit for military service. If the money is truly given as a bribe, the crime committed is corruption of a public officer, not estafa. Furthermore, the offender may also be liable for defamation against the government employee who was allegedly bribed. We are continuing our discussion on swindling or estafa, as defined in Article 315 of the Revised Penal Code. This includes 5 modes of committing estafa by means of fraudulent acts, such as altering the quality, fineness, or weight of an item related to the offender's art or business. This encompasses manipulation of scales, tampering with weights and measures, and tampering with taximeters. Another mode of committing estafa involves post-dating checks, or issuing checks in payment of an obligation when the offender had insufficient funds. Failure to deposit the necessary amount to cover a dishonored check within 3 days of notice serves as prima facie evidence of deceit. The elements of estafa by post-dating checks include the offender post-dated or issued a genuine check in payment of an obligation contracted at the time of issuance and delivery of the check. Issuing a bouncing check for a pre-existing obligation does not constitute estafa. The accused must have obtained something from the offended party via the check. Furthermore, if checks were issued merely by a guarantor, there is no estafa. Post-dating or issuing a check when the offender has insufficient funds is sufficient for liability. However, if post-dated checks were issued solely as promissory notes, no estafa is committed, even without sufficient bank funds. It is necessary that the person receiving the check is defrauded. Failure of the drawer to deposit the necessary amount is prima facie evidence of deceit. Good faith is a defense if the accused issued the check believing they could cover it and attempted to make arrangements before the due date. Stopping payment of a post-dated or insufficient funds check is unavailing if the drawer intended to stop payment at the time of issuance. A person using an unfunded check, knowing the drawer had no funds, for the purchase of goods is guilty of estafa. Presidential Decree Number 818 increased penalties for estafa committed by bouncing checks. Batas Pambansa BLG 22 complements Article 315 by adding an element of knowledge regarding insufficient funds, which was previously eliminated from the Revised Penal Code. Unlike the Revised Penal Code, BPBLG 22 makes deceit and damage immaterial, and the crime is against public interest rather than property. Batas Pambansa BLG 22 can be violated in two ways. First, by issuing a check knowing there are insufficient funds or credit, which is subsequently dishonored, or by issuing a stop payment order without valid reason. Second, by having sufficient funds at the time of issuance but failing to maintain them for 90 days, leading to dishonor. The elements of the first mode of violating BPBLG 22 include a person making, drawing, and issuing a check, the check being issued to apply on account or for value, and the person knowing they have insufficient funds or credit at the time of issue. Knowledge of insufficient funds is legally presumed upon dishonor, with exceptions. The first mode is completed when the check is subsequently dishonored for insufficient funds or credit, or would have been dishonored if the drawer had not, without valid reason, ordered a stop payment. It is no defense that the check was not actually dishonored, if the possibility existed. The elements of the second mode of violating BPBLG 22 include a person having sufficient funds or credit when issuing a check, failure to maintain sufficient funds or credit to cover the check if presented within 90 days, and the check being dishonored by the drawee bank. The gravamen of BPBLG 22 is the issuance of the check, not the non-payment of an obligation. Obtaining food or accommodation at a hotel or similar establishments is another mode of estafa. This can be done by obtaining services without paying, with intent to defraud, obtaining credit using any false pretense, or abandoning or surreptitiously removing baggage after obtaining services on credit without paying. Estafa can also be committed by inducing another, through deceit, to sign a document. An element of this type of estafa is that the offender must have induced the offended party to sign a document. If the deceit relates only to the document's contents and the party willingly signed, the crime is falsification, not estafa. Deceit must be employed by the offender to make the offended party sign the document, thereby misleading them about its character. Absent such proof, there is no estafa under Art 315, number 3A, and the complainant's remedy may be a civil action. Other elements of estafa by inducing signature include the offended party personally signing the document, and prejudice being caused to the offended party. Also, resorting to fraudulent practice in a gambling game to ensure success can constitute estafa. Estafa can also be committed by removing, concealing, or destroying any court record, office files, documents, or other papers, as specified in Article 315, Number 3, Section C of the Revised Penal Code. The elements of this estafa are the presence of court records, office files, documents, or other papers, and the offender removing, concealing, or destroying any of them. This form of estafa covers different actions, such as removing documents, concealing documents like one evidencing a deposit, and destroying documents, such as a promissory note given back to the maker for renewal but never replaced with a new one. Estafa by removing, concealing, or destroying documents is distinct from infidelity in the custody of documents. In estafa, the offender can be a private individual or a public officer not entrusted with the document, and intent to defraud is required. If there is no intent to defraud, destroying a court record may be considered malicious mischief. Welcome to this video on crimes against property. We will explore a diagnostic framework for Title 10 of the Revised Penal Code, synthesizing statutory elements, jurisprudence, and special penal laws. The legal classification of a property crime depends on how the offender bypassed the owner's consent. This is categorized into three main means: force, stealth, and deceit and trust. Robbery involves the element of coercion or force. This can be violence or intimidation against a person, where the property's value is immaterial, or force upon things, which requires entry into a building or breaking a sealed receptacle, and the penalty depends on the property's value. Robbery can escalate into complex crimes, such as robbery with homicide. The intent precedence rule is key. If the intent to gain precedes the killing, it's robbery with homicide. If the intent to kill precedes the taking, it results in two separate crimes, murder/homicide plus theft. This diagnostic matrix differentiates robbery in band from brigandage. Brigandage, or highway robbery, targets the organization itself, where the mere formation of the band is punishable. Robbery in band targets a specific act, and mere conspiracy is not punishable. Theft, under the element of stealth, involves the unlawful taking of personal property belonging to another, without violence, intimidation, or force upon things, and without the owner's consent. Theft is consummated the exact moment the thief gains full possession of the property. Qualified theft Article 310 involves a breach of trust or special targets. This includes theft by domestic servants or those with grave abuse of confidence. It also covers special property like motor vehicles or agricultural products taken during calamities. The diagnostic matrix helps distinguish robbery from theft. The critical difference is whether the taking involved violence or intimidation of a person. Force upon things to enter a building is robbery, but force only to break a fence or corral is theft. The ecosystem of stolen goods includes two paths beyond the initial taking. Path A is theft by omission, where a finder fails to deliver lost property. Path B is fencing, involving buying, receiving, or concealing stolen property. In both paths, the property remains personal property belonging to another. Usurpation is the theft of immovable property. Occupation of real property, Article 312, requires violence or intimidation of persons. Altering boundaries, Article 313, penalizes the mere alteration of boundary marks. Usurpation targets real property, unlike robbery and theft, which target personal property. Estafa, the architecture of deceit, has two pillars and a foundation. Pillar 1 is abuse of confidence, involving the transfer of juridical possession. Pillar 2 is means of deceit, where trickery causes the handover. The foundation for both is damage or prejudice, capable of pecuniary estimation. Misappropriation, a form of estafa, follows 4 steps: lawful receipt of juridical possession, conversion or denial, prejudice to the owner, and a formal demand. A key consideration is the civil liability trap. If a contract transfers ownership, failure to pay is a civil liability, not estafa. The bouncing check compares estafa versus BP 22. Estafa is a crime against property, where the check must be for a simultaneous obligation, requiring proof of deceit and damage. BP 22 is a crime against public interest, where the check can be for a pre-existing obligation, and the gravamen is the mere issuance of a worthless check. Fraudulent insolvency, Article 314, occurs when an offender, as a debtor, absconds with their property, resulting in prejudice to creditors. Absconding does not require physical flight. A sham deed of sale is sufficient. Actual prejudice to creditors is mandatory for conviction. This diagnostic tree provides a grand synthesis for classifying property crimes. It guides you through questions based on what was taken and how consent was bypassed, leading to the correct classification: usurpation, theft, estafa, or civil liability only.
Right, let's just dive right into this. Today, we're going to decode the anatomy of a steal. We're looking specifically at this explainer of the Philippine Revised Penal Code and how it categorizes, defines, and penalizes crimes against property. Honestly, if you think stealing is just a simple, straightforward concept, prepare to be surprised. The law is incredibly structured, almost like a giant puzzle, and we're going to break down that structure together. So let's start with a little scenario to test your legal instincts. Picture this: someone snatches a bag and runs away. Is that considered robbery or theft? In everyday conversation, we'd probably all say, hey, I was robbed. But legally? Well, according to the jurisprudence in the People versus Villar case, snatching a bag and running away is actually classified as theft, not robbery. Crazy, right? This just goes to show that the law is far more nuanced than our everyday vocabulary. To really understand why that's theft, we need to look at the foundational rules. All right, let's look at the anatomy of stealing and its baseline elements. Every single crime against property in this code shares a specific DNA. Think of these as the mandatory building blocks. These fundamental elements are simple but absolutely crucial. First up, there must be a taking of personal property. Second, that property has to actually belong to someone else. And third, and this is the kicker, there must be an unlawful taking with an intent to gain. That last part is vital. The law literally states that the intent to gain is presumed from the unlawful taking. But what if you take something belonging to another, unlawfully but absolutely without any intent to profit or gain? Well, actually, Scratch that. It's not even stealing anymore. According to the code, the crime becomes something entirely different, grave coercion. So the intent to benefit is the engine that really drives a property crime. Moving on to robbery, when stealing escalates. Now that we've got our baseline, what happens when stealing gets a bit more aggressive? So under Article 293, robbery takes all those baseline elements we just talked about, personal property, belonging to another, intent to gain, and it adds a pretty nasty method to the mix. It requires the taking to be done by means of violence against or intimidation of any person, or by using force upon anything. It is this aggressive method that radically elevates the severity of the crime from mere theft to robbery. Now, the law actually treats these two aggressive methods super differently. When a robbery involves violence against or intimidation of people, the actual monetary value of the stolen item, it's generally immaterial to the core classification of the crime. The violence itself is the primary issue. However, when we look at force upon things, like, say, breaking a lock or smashing a wall, the exact value of the property taken suddenly dictates the severity of your penalty. Let's zoom in on that second part. Robbery using force upon things. This usually involves break-ins, but the law is incredibly strict about where it happens, meticulously categorizing buildings, particularly what it considers an inhabited house. You know, legally speaking, an inhabited house isn't just your standard traditional building. It's any shelter, ship, or vessel constituting a dwelling, even if the people are temporarily absent. There is this incredible jurisprudence on this from a case called U.S. versus Ray. In that case, the Supreme Court ruled that a sunken ship still counted as an inhabited house. I mean, no way, right? The culprits basically took boxes reinforced with iron straps from the sunken vessel, broke them open, and took the money. But because it was a vessel meant for dwelling, it qualified under this incredibly strict definition, even sitting at the bottom of the sea. Okay, here's a really fascinating legal twist for you. In People versus Adorno, the accused broke the glass of a bazaar's show window and grabbed 40 watches. Now, you'd think that's robbery by force upon things for sure, right? Wrong. The court ruled it was theft. Why? Because the law strictly requires actual entry into the building for it to be robbery with force upon things. The accused merely reached his hand through the broken glass. He never actually physically entered. Therefore, the crime reverted right back down the scale to theft. All right, shifting gears to brigandage, organized highway crime. We're scaling things way up now, moving from individual acts of robbery to an organized, terrifying scale penalized under Article 306. So brigandage requires at least 4 armed persons forming a band. But here is the kicker. Their primary purpose must be committing robbery in the highway, kidnapping for extortion, or attaining purposes by force. The law comes down so incredibly hard on this that if any single member of this band carries an unlicensed firearm, all of them are legally presumed to be highway robbers or brigands. Now, you might be wondering, what is the difference between a robbery in band and brigandage? It's a hair-splitting, yet vital legal boundary. If 4 armed men get together to plot the robbery of one specific target, say a particular bank or a specific house, that is robbery in band. But brigandage is different. It's an organization formed for general, ongoing terror. It's a group that literally roams the highways specifically looking for opportunities to rob or kidnap, not just executing a single predetermined plot. Okay, let's bring the severity scale back down a notch. We are leaving the violent world of robbery and brigandage to explore the stealthy, non-violent world of ordinary theft under Article 308. The absolute most crucial point here is the word without. Theft relies purely on the lack of force. There's no violence, no intimidation, no breaking of walls or locked chests. It is simply taking property with intent to gain, coupled with the absolute lack of the owner's consent. And this leads to some pretty wild scenarios. Take the case of People versus Murillo, for instance. The offender was super angry because someone else's cattle destroyed his plantation. So, in revenge, he shot and killed the cattle and then distributed the meat among himself and his neighbors. It started as an act of angry revenge, and, let's be honest, a totally bizarre way to deal with a cow problem, but because he took the meat and benefited from it without the owner's consent, the law classified the whole shebang as simple theft. So say you're walking down the street and you find a lost wallet. You decide to keep the cash. Did you commit theft? I mean, the old playground rule is finders keepers, losers weepers, right? But does the penal code agree with that? Well, the answer is a resounding no. Finding is stealing if you don't return it. The law explicitly defines a special form of theft, failing to deliver found lost property to local authorities or its owner. There's even this fascinating concept called a finder in law. In the People v. Avalo case, a policeman was entrusted with a lost bundle of money to deliver to the actual owner. Instead, he just kept it. The court ruled he took the place of the finder, and by misappropriating it, he was convicted of theft. Which brings up another really interesting point. What exactly do we consider property? In the Nativity versus Court of Appeals case, a meter reader knowingly misread electric consumption, allowing the consumer to essentially take electricity without paying for it. And the court ruled this is theft. It just perfectly illustrates that even intangible things, like electricity or gas, are considered valuable merchandise capable of being stolen. Finally, let's look at one last severe escalation: qualified theft, the ultimate betrayal. We've covered stealing with violence and stealing by stealth. Now let's look at stealing through broken trust. The Penal Code actually bumps the punishment up 2 whole degrees if specific conditions are met. If a domestic servant steals from their master, it is always considered qualified theft, because that role inherently involves profound trust. However, if a regular housemate steals from another housemate, it isn't automatically qualified. Living together might just be accidental. To elevate a housemate's theft to qualified theft, the prosecutor must actually prove there was a grave abuse of confidence. Let's end on this thought. Imagine you are given shelter out of pure charity, and while staying there, you steal your protector's money. Based on everything we've just covered, is that just ordinary theft? Well, according to the Mariano versus People case, the courts view this as a grave abuse of confidence, elevating it straight to qualified theft. It really makes you think, doesn't it? The law doesn't just look at what was taken. It looks very, very closely at exactly how you took it and who you betrayed to get it. So the next time you think about the concept of stealing, ask yourself, are you just looking at the act or the anatomy behind it?
You know, if you break your arm, an X-ray gives you a clean binary answer.
Right. It's right there on the screen.
Exactly. You look at the film, you see the jagged white line, and the doctor says broken. And it's comforting in a weird way.
Yeah, we really like things to be visible. We like behavior to be neatly categorized.
We do. But when you step into the world of the legal system, specifically criminal law, that X-ray machine is just, well, it's broken. The diagnostic landscape is super murky.
Oh, absolutely.
Because the line between, a petty thief, a hardened criminal, and a completely innocent bystander, it isn't just jagged, it moves.
It shifts constantly.
Right. It shifts depending on who is standing where, what they were thinking in like a fraction of a second, and sometimes bizarrely, what kind of agricultural product is involved.
It really is the absolute definition of diagnostic muddy waters.
Mm-hmm.
And, that is exactly what makes the law so endlessly fascinating. Mm-hmm. The legal system is essentially this massive machine trying to take the infinite, totally chaotic, unpredictable spectrum of human behavior and force it into highly specific boxes.
Yeah, which is an impossible task.
It really is. When it comes to property, to human beings taking things from other human beings, the law is forced to become, a philosopher, a psychologist, and an economist all at once.
And that is exactly what we are exploring today on the Steep Dive. We are taking a massive, meticulous look at how the law defines the taking of property.
It's a great topic.
We've got a fantastic grounding source today, too. We're looking at a really detailed legal syllabus on criminal law 2 by Lorenzo U. Padilla. Specifically, we're focusing on Title 10, which is crimes against property.
Yeah, Padilla's breakdown is incredible for really untangling these rules.
It is, because our mission today isn't just to throw legal jargon at you. We want to dive deep into the architecture of these rules, looking closely at how the legal framework separates different types of theft, coercion, and deceit.
Right.
Because to you, the listener, whether you're negotiating a contract or running a business or just trying to understand the invisible rules that keep society from collapsing, understanding these boundaries is crucial.
It's fundamental.
Yeah, it's not just about what is taken. It is entirely about how you take it, who you take it from, and the psychological state of the person doing the taking.
Precisely. If we connect this to the bigger picture, property law is really a reflection of what a society values and, crucially, what a society fears.
Right, what keeps us up at night.
Exactly. It's a mirror of our vulnerabilities. We aren't just protecting a watch or a car. We are protecting the concept of ownership, the sanctity of our homes, and, the trust that allows a market economy to even function.
Yeah.
When the law punishes a thief, it's not just trying to get the watch back. It's trying to repair a tear in the social fabric.
Wow, yeah. So let's start at the most primal level of that tear, Let's look at the forceful take. Robbery.
The big one.
Right. When most people hear the word robbery, they use it totally interchangeably with theft. Like, someone says, oh, my house was robbed, when they really mean someone snuck in and stole their TV while they were on vacation.
Happens all the time. People mix them up constantly.
But the law makes a massive fundamental distinction here based on Padilla's syllabus. Robbery requires a specific type of breach. It requires aggressive force.
It does. The legal definition hinges entirely on the method. Robbery is the taking of personal property belonging to another with the intent to gain, using either violence or intimidation against persons or force upon things.
That or is doing a lot of heavy lifting.
That or is the pivot point. It is the violence, the psychological intimidation, or the physical force used to break a barrier that elevates a mere taking into a robbery.
So it's the aggression.
Exactly. It's the aggression that the law is targeting here, almost more than the loss of the property itself.
Let's break down that first half, violence versus intimidation. Because violence makes intuitive sense to me. Someone punches me in an alley and takes my wallet. That is a physical, overpowering, boom, robbery.
Right, clear cut.
But intimidation, that feels incredibly subjective. Where does the law draw the line on what constitutes enough intimidation to turn a taking into a robbery? Like, does someone have to physically hold a weapon to your head?
What's fascinating here is how broadly the courts have interpreted intimidation, because they recognize that human will can be broken in a lot of different ways.
Okay.
It absolutely does not require a physical weapon. It doesn't even require the threat of immediate bodily harm. The jurisprudence shows cases where the threat was entirely economic.
Oy, economic.
Yeah.
Yeah.
For instance, the source notes a well-known legal scenario where the threat of closing down someone's store, of ruining their livelihood, was deemed sufficient intimidation to constitute robbery.
Let me stop you there, because that is a massive conceptual leap.
It is.
You're saying, like, give me your money or I'll use my influence to get your business license revoked and shut down your store. The law looks at that white-collar, bureaucratic threat and puts it in the exact same legal bucket as holding someone up at gunpoint.
Conceptually, yes, because intimidation in the legal sense is about causing fear or fright that compels the victim to part with their property against their will.
Right.
It's about overcoming the autonomy of the owner. If you hold a knife to someone, you're saying your money or your life. If you hold the power to destroy their business and you weaponize it, you are saying your money or your ability to feed your family.
Wow.
The psychological coercion, the extinguishing of the victim's free will, is what the law is punishing. The method of coercion is almost secondary to the fact that the coercion was absolute.
That makes a terrifying amount of sense when you put it like that. It's about the paralysis of the victim.
Exactly.
If I am paralyzed by the fear of losing my livelihood, my consent to give you my property is completely manufactured. It's just a hostile takeover of my decision-making.
You nailed it. And the law scales its punishment based on the chaos that this aggression unleashes. Which brings us to a the on-the-occasion rule.
The complex crimes.
Yeah. The law knows that when you introduce violence or intimidation into a situation to take property, you are essentially lighting a fuse. You are creating a highly volatile scenario.
Right, it's about the escalation. If a robbery spirals out of control, the law treats it as a single massive compound crime.
Yes.
Padilla's text says, if a homicide, a rape, or an intentional mutilation happens by reason or on occasion of the robbery, it becomes this ultimate mega crime. It's not just charged as two separate things. It fuses into, say, robbery with homicide.
And this is where the law's attempt to deter the escalation of violence becomes incredibly strict.
How strict?
Well, the phrase by reason or on occasion of is interpreted with a really sweeping net. The core requirement is that the original intent to take the property must precede the killing. You have to have gone in there to rob.
Okay, so the robbery is the foundation.
Right. But as long as that intent was the spark, the homicide can happen before the actual taking, during the taking, or while running away.
So if a bank robber shoots a security guard on the way out the door to secure their escape, that is clearly robbery with homicide. The killing was a direct tool to facilitate the robbery.
Very direct, yes.
But what if the connection is less direct? Like, what if things just get messy?
This is where the strict liability of the powder keg comes in. The law's stance is essentially you created this dangerous, illegal situation. You brought the spark to the powder keg.
All right.
Therefore, you are responsible for any explosion that happens, even if you didn't specifically intend for that exact explosion to occur.
Okay, give me an example.
Well, the most extreme application of this, and this usually shocks people studying the law, is that the mega crime of robbery with homicide still applies, even if the person killed is one of the robbers themselves.
Wait, I really need to unpack this. Let's run a hypothetical. 3 armed individuals go into a jewelry store. The owner pulls out a shotgun from under the counter and fires in self-defense. He instantly kills robber A. Okay. Robber B and robber C grab the bags of diamonds, dive through the shattered door, and escape. When B and C are caught, you're telling me the state charges them with the homicide of their own partner. The partner they loved, the partner they didn't even shoot.
Yes, they can absolutely be charged with the complex crime of robbery with homicide.
That is wild.
It is, but the reasoning is deeply rooted in causality and public policy. The courts have consistently held that the death supervened on the occasion of the robbery.
Because they started it.
Exactly. If they had not initiated the violent felony of the robbery, their partner would not be dead. The law doesn't care that they didn't pull the trigger. The law cares that they authored the chain of events that resulted in a loss of human life.
It's an ultimate accountability mechanism. It's society saying, if you choose to use violence to take property, you forfeit the right to say, oh, it was an accident when the violence spirals out of your control.
Precisely. Consider another scenario. During the sheer panic and chaos of a home invasion robbery, a resident tries to run away, trips down a flight of stairs in the dark, breaks their neck, and dies.
Oh, wow.
The robbers didn't touch them, they didn't push them, but the robbers are still liable for the special complex crime. The fear they instilled caused the flight caused the fall caused the death. The law draws a straight, unbroken line of culpability.
It's a terrifying deterrent. Okay, so that covers the violence and intimidation against persons. But the other half of the robbery definition is force upon things.
Yes.
This is the breaking and entering component. And this is where the law becomes almost obsessed with geometry and architecture.
I love that phrase, the meticulous geometry of the law. For force upon things to elevate a taking to a robbery, there must be a violation of a physical boundary.
Like a house.
Right, the physical perimeter of a structure, a domicile, or a building is treated as sacred space. The syllabus lists specific methods, right? Using false keys, breaking walls, roofs, floors, or entering through openings not intended for entrance.
Like shimmying down a chimney or crawling through a basement air vent. You are subverting the intended architecture of the house to breach its security.
Exactly.
But I want to push back on this boundary concept because there is a famous legal distinction in the source that frankly sounds absurd until you really drill down into it. It's about the show window of a store.
Ah, yes. The classic people versus Adorno precedent. Let's get into it.
Okay, picture this. I walk up to a high-end watch boutique on a city street. I have a brick. I throw the brick with maximum force, shattering the thick glass of the display window. Glass goes everywhere.
Very dramatic.
Thank you. I reach my arm through the jagged hole, grab 40 expensive watches off the display pillows, put them in my bag, and walk away. I used force. I broke a thing. But Padilla's text says this is not robbery. It is only theft.
That's right.
How does that make any sense? I literally smashed their building. Why isn't that robbery by force upon things?
It's a brilliant friction point, and it perfectly highlights how strictly criminal statutes must be construed. The analysis hinges entirely on one specific word in the legal requirement. Entry.
Yeah. Entry.
Right. The law for robbery with force upon things is specifically designed to punish the violation of the sanctity of the interior space. You have to actually introduce yourself into the domain of the victim.
So my arm crossing the plane of the window doesn't count as me being in the building.
Correct. The courts have drawn a hard, physical, bodily line. Extending or introducing a hand through a broken glass to remove an object does not constitute an entry into the building in the legal sense required to trigger the robbery statute.
Even though I broke it.
You used force to break the glass? Absolutely. You would likely be charged with a crime of malicious mischief or property damage in addition to the taking. But because your entire body did not cross the threshold and enter the structure, the primary elevating element of that specific type of robbery is missing. Wow. Therefore, the taking itself downgrades to theft.
That is wild. It's like playing a high-stakes game of legal tag where the base is the actual floorboards of the store. If the soles of my shoes don't touch their floorboards, I haven't officially entered their domain.
It seems pedantic on the surface, but consider why the court has to do this. They are protecting the consistency of the law. If they blur the line and say an arm counts as entry, what's next?
Right, where does it end?
Exactly. Does holding a stick with a hook on it through the window count as entry? Does tossing a trained monkey through the window count? Does shining a laser pointer inside count?
Okay, the monkey example is great.
The law abhors a slippery slope when it comes to taking away someone's freedom. So the court drew a definitive, undeniable physical line. The body of the offender must enter the premises. If it doesn't, it's a destructive theft, but it is not robbery.
So robbery is fundamentally about the aggressive breach. It's either breaking the psychological will of a human being through fear, or literally breaking the physical barrier of a building and stepping your whole body inside.
Nicely summarized.
It's loud, it's confrontational, and it violates a boundary. But what if a criminal doesn't want to break the barrier? What if they realize that a sledgehammer draws too much attention and they'd rather use a scalpel?
Then we move to a different category.
Right. That brings us to the stealthy side of the spectrum. Let's talk about the nuances of theft.
The scalpel is the perfect analogy. If robbery is a confrontational breach, theft is the quiet, unconsented taking of property. We transition entirely away from violent coercion and physical breaking and move into the realm of stealth, speed, and opportunity.
The baseline definition of theft, according to Article 308, is taking personal property belonging to another with intent to gain, without violence or intimidation, and without force upon things.
Sounds very straightforward.
It sounds so simple. You look away at a coffee shop, I slide your laptop into my bag, I walk out. That's theft. But the legal framework gets incredibly granular about the timeline. Specifically, it obsesses over exactly when the crime is actually complete.
Oh, the timing is everything.
Like, at what precise millisecond does an attempted theft become a consummated, finished, prosecutable theft?
Well, the law uses a specific term for the taking and carrying away of property, which is asportation. And the general rule is that theft is consummated the very moment the offender gains possession of the thing, even if they only hold it for a second, and even if they don't have the opportunity to dispose of it or sell it.
Just asserting control.
A moment you assert control over it, the crime is done.
But control is a fuzzy concept depending on where you are. I want to look at the checkpoint examples from the syllabus because they perfectly illustrate how the law measures control.
The compound examples, yes.
Yeah. Imagine a massive, enclosed industrial compound with a security gate at the front. A thief sneaks in. Let's compare two different targets. Target A is a massive, bulky piece of industrial machinery, like a forklift engine. Target B is a duffel bag full of expensive, non-bulky computer chips.
Excellent comparison.
So in scenario A, the thieves manage to unbolt the bulky engine. They get it onto a flatbed truck inside the compound. But before they can drive the truck out of the main security gate, the guards catch them.
Caught red-handed.
Right. The courts have historically ruled this is only frustrated theft. They tried, they got far, but they failed to consummate the crime. However, in scenario B, the thief puts the non-bulky computer chips into a duffel bag, walks out of the warehouse riding, gets into their personal car still parked inside the compound, and is caught by security before reaching that same main gate.
Same location of capture.
Exactly. But the courts say that is consummated theft. Why does the size of the object change the completion of the crime when both thieves were caught inside the exact same fence?
It all comes down to a legal doctrine regarding the freedom to dispose. The court is asking, at the moment of capture, did the thief have a palpable, realistic ability to do whatever they wanted with that property?
Okay, so the engine.
Right. In the case of bulky goods, the engine, even if you have it loaded on a truck inside the compound, your ability to freely dispose of it is still heavily restricted by the physical reality of the gate. You can't hide it. You can't toss it over the fence. You haven't truly wrested control from the owner's domain yet.
Because I can't just put a 1-ton engine in my pocket and slip through a hole in the fence. My control is an illusion until I clear the massive gate designed to stop trucks.
Exactly. The determinative factor is the ability to dispose freely, even momentarily. The bulky goods couldn't be disposed of until they cleared that final bottleneck.
And the chips.
But with the non-bulky computer chips, the moment the thief got them out of the building and secured them in the trunk of their personal car, they had achieved a completely different level of control.
Because they're small.
Right. They could have hidden them under a seat. They could have tossed the bag over the fence to an accomplice. They could have buried them in the dirt on the compound. Their freedom to dispose was vastly less restricted. So the court deems the taking complete, the theft consummated, even though they hadn't exited the main compound gate yet.
That is a brilliant distinction. It's not about the geographic boundary of the fence. It's about the threshold of control.
Exactly.
The moment you possess enough autonomy over the object that you could theoretically pivot and do something else with it, the owner's right has been severed. The theft is complete.
Precisely.
Okay, so that covers the mechanics of the taking. Now we have to talk about the psychology of the thief. The intent to gain. The legal term here is animo lucrandi.
Yes. The animating spirit of the crime. Why did they take it?
I have always assumed, and I think most people assume, that gain means financial profit. You steal a watch to pawn it for cash. You steal a car to sell it to a chop shop. It's an economic transaction.
Right. That's the colloquial understanding.
But the law's definition of gain is way broader and, frankly, way weirder than just money.
It is vastly broader. The law recognizes that human beings are motivated by things other than currency. Gain encompasses utility, satisfaction, enjoyment, or pleasure. Taking an object to extract its usefulness, even temporarily, is a legal gain.
Let's talk about the joyride precedent, because this is fascinating.
Oh, this is a classic.
There are cases where individuals took horses, and in modern times, cars, without permission. They drove them to a dance or took them for a spin around the county, and then fully intended to bring them back. They didn't sell them, they didn't dismantle them, they just borrowed them without asking.
Unconsented borrowing.
Right. But the courts ruled this was theft. Why? Because the purpose was to utilize the property. The joyride itself was the gain.
Exactly. They extracted utility and pleasure from the property of another without consent. The law says you do not have the right to mine someone else's property for your own enjoyment, even if you return the mine intact.
Oh, I like that analogy.
The wear and tear, the fuel, the sheer unauthorized exertion of control, that is a transfer of value.
Yeah.
In the eyes of the law, that utility is a form of wealth that you stole.
So even if I absolutely plan to bring your car back with a full tank of gas and I leave it perfectly washed in your driveway, if I took it while you were asleep just so I could arrive at a high school reunion looking wealthy, I have stolen your car.
Yes.
Because I gained the utility of social status for 3 hours.
In the strictest legal sense, yes, that fulfills the elements of theft. The intent to gain was the extraction of that temporary social utility. But it goes even further into purely psychological territory. The law even considers emotional satisfaction as a form of gain.
The revenge case. This completely shattered my understanding of theft when I read it in the syllabus. Let's walk the listener through this.
It's a really stark example.
There is a precedent involving an employee who was furious at his boss. Just pure, unadulterated hatred. So the employee sneaks into the office, takes a stack of highly confidential, sensitive papers belonging to the employer, and mails them to government investigators.
Just to cause trouble.
Right. His motivation was entirely vindictive. He wanted to see his employer investigated, harassed, and ruined. He didn't ask the government for a bounty. He didn't make a single dime off the papers. He just wanted the boss to suffer.
And the court found that this satisfied the intent to gain requirement for theft.
How? How is spite a gain?
Because the court held that the satisfaction of taking revenge, the pleasure of seeing the employer harassed and legally entangled, constituted a real tangible gain to the perpetrator.
Wow.
The gain was emotional and psychological. They consumed the property's value by weaponizing it for their own emotional payoff. Now, it's worth noting that in legal circles, this is highly debated.
I would imagine.
Yeah, there was a strong dissenting opinion in that specific case, arguing that animo lucrandi must mean greed, a desire for material enrichment, and not just a feeling of hatred or revenge.
But the conviction held up.
It did. And the prevailing view that upheld the conviction highlights how expansively the law is willing to interpret human motivation. If an action feeds your desires, whatever they may be, by illegally utilizing someone else's property, the law is comfortable calling you a thief.
That is wild. Satisfaction as a legally recognized currency of theft. It means the law is constantly trying to put a price tag on human emotions.
That's a good way to phrase it.
Okay, I want to present a hypothetical to you that deals with everyday morality because this next concept really challenged me. Let's talk about lost property.
A classic ethical and legal quagmire.
The rule in the text is clear. Failing to deliver found lost property to the authorities or to the owner is theft. So, to you, the listener, imagine this scenario. You're walking down a busy city sidewalk, you look down, and there's a thick leather wallet lying right over a subway grate.
A tempting scenario.
You stop, you pick it up, you open it. Inside is a driver's license, some credit cards, and 3 crisp $100 bills. You look around, no one is there. You take the $300, slip it into your pocket, and then you drop the wallet right back onto the grate where you found it. You keep walking.
Okay.
Under the law, are you just an opportunistic finder, or are you a thief? It feels like the universe just put it in your path. You didn't pick anyone's pocket.
It's a very common rationalization, but the law vehemently disagrees. You are a thief. This raises an incredibly important point about the legal responsibilities of living in a shared society. Based on cases like People versus Avila, when you pick up that wallet, you aren't just a passive passerby anymore.
What am I?
By taking physical, deliberate possession of the lost property, you undergo a legal transformation. You become what is known as a finder-in-law.
So the moment my fingers close around the leather, a contract is formed.
Essentially, yes. You assume a voluntary substitution for the owner. You step into their shoes as the temporary lawful custodian of that property. The law grants you the right to hold it, but it burdens you with the duty to return it.
So I have an obligation.
Right. If you keep the cash and leave the wallet, you aren't just failing to be a good Samaritan. You are actively misappropriating property that you know, factually, belongs to someone else.
Because the cash wasn't abandoned, it was lost. The owner still has a legal claim to it, even if they don't know where it is.
Precisely. The law infers your intent to gain from your deliberate, conscious failure to deliver the property to the proper person or the authorities. You didn't take it from their physical pocket, but you took it from their legal domain the exact moment you decided to keep it instead of initiating the return.
That's a huge shift in perspective.
The universe didn't give you a gift. It gave you a test of your legal obligations to the social contract.
I love that phrasing. A test of the social contract. And before we close the book on theft, we have to talk about how technology is stretching these definitions. Because personal property isn't just a wallet or a car anymore, it's invisible.
Intangibles, yes.
The law explicitly notes that personal property includes intangibles like electricity and gas.
Yes, the evolution of appropriation. As our world becomes more technological, the things of value become less physical.
There's a fascinating precedent involving an electric company and a meter reader. The meter reader was bribed by a homeowner to knowingly misread the electric consumption month after month.
Just altering the numbers.
Exactly. The meter would show 1,000 kilowatts and the reader would log 200. The homeowner was using massive amounts of electric current without paying for it. And the court treated the invisible flow of electricity as a valuable article of merchandise, fully capable of being stolen.
And logically, it must be. It requires massive infrastructure, coal, water, or solar power to generate. It has a definitive economic value. So, tampering with a meter or using a jumper cable to deflect current around the meter and into your house is legally theft, just as surely as if you walked into the utility company and stole a desk.
It's the same thing.
It forces us to realize that theft isn't about grabbing a physical object. It's about the unauthorized diversion of value.
Which is a perfect pivot point. We've talked about the violent strangers kicking down the door in robbery. We've talked about the opportunistic strangers quietly slipping things into their pockets or tapping into power lines and theft.
Right.
But what happens when the thief isn't a stranger? What happens when the thief is someone you invited inside, someone you literally trusted with the keys?
It changes everything.
That brings us to our next major concept, the ultimate betrayal and the devastating crime of qualified theft.
This is where the law becomes intensely focused on relationships. If simple theft is a violation of property rights, qualified theft is a violation of property rights compounded by a deep violation of trust, or a violation against a critical societal interest.
And the punishment reflects that.
Oh, it punishes this betrayal fiercely. Qualified theft is punished 2 degrees higher than simple theft.
And just to clarify for the listener, in the penal system we're analyzing, 2 degrees higher is not a minor bump in a fine. It is a massive life-altering jump in penalty. It's the difference between a slap on the wrist or probation and spending a significant portion of your life in a maximum security prison.
The law is bringing the hammer down.
So what qualifies it? How does a theft get upgraded? It boils down to the who and the what. Let's start with the who. The prime classic example is the domestic servant.
Yes. The law views the home as the ultimate sanctuary. When you hire a domestic servant, a live-in nanny, a housekeeper, a caretaker, you are allowing a stranger into your inner sanctum.
You're opening your whole life up to them.
Exactly. You are exposing your most private life, your valuables, and your family to them 24 hours a day, 7 days a week. You are inherently vulnerable. Therefore, the law acts as a supreme deterrent. Theft by a domestic servant is always considered qualified theft.
And what's interesting is that the prosecutor doesn't even have to prove that there was a grave abuse of confidence in the specific act. If my housekeeper steals a watch off my nightstand, the state doesn't have to prove I explicitly said, hey, I trust you to guard this watch.
Exactly right. The position itself implies the confidence. The intimate proximity dictates the trust. If you violate that proximity, you face the maximum penalty.
Makes sense.
But the jurisprudence draws a really sharp, fascinating distinction when it comes to other types of employees. A domestic servant stealing is qualified theft. But what about a common laborer? Say you hire a crew of construction workers to build an addition on your house, and one of the laborers steals a valuable tool from the site. Is that qualified theft because he's an employee?
Based on the precedents in Padilla's text, no. It's usually just simple theft, and that feels contradictory at first glance. They're both employees working on your property. Why the difference?
It all comes down to the nature of the access and the intimacy of the trust. A common laborer on a construction site, or a warehouse worker moving boxes, does not inherently have the same level of intimate trust or access to personal, secured valuables as a live-in maid.
They're just on the premises.
Right. Merely being on the payroll doesn't automatically create that special relation of confidence that the law seeks to protect. The laborer has physical access, yes, but not emotional or structural trust.
But wait, the law is incredibly nuanced here. Because there's another case involving a radio technician working at a military signal depot.
Ah, yes.
This technician smuggled highly valuable, specialized radio tubes out of the depot where he worked, and the courts ruled that was qualified theft. He wasn't a domestic servant, he was just a guy working in a depot. Why did he get the hammer, but the construction worker didn't?
Excellent question. It highlights the exact mechanism of trust. The radio technician had specific access to the very items he stole because of his specialized role.
Ah, because of his job.
The radio tubes were essential for his daily work. The government, his employer, implicitly trusted him to handle, repair, and safeguard those specific items. It's similar to a bank teller taking cash from their own drawer.
That makes total sense.
The teller isn't a domestic servant, but taking the very thing they are exclusively trusted to guard is a grave abuse of confidence. The trust was the vehicle for the crime. The construction worker stealing a random tool doesn't necessarily abuse a specific, granted trust. The radio technician weaponized the specific trust given to him.
That is a brilliant distinction. It's about the vehicle of the crime. Did you use the trust as the lockpick to get the goods? If so, you committed a qualified crime. Okay, so that's the who, the betrayal of the trusted insider. Now we have to talk about the what, because this is where the law gets incredibly, almost comically specific about what items are so vital to society that stealing them automatically triggers the massive penalties of qualified theft.
This list always surprises people.
The list includes motor vehicles, mail matter, large cattle, and coconuts.
Yes, the infamous coconut exception.
I really need you to walk me through this, because on its face, it sounds like a punchline. I understand motor vehicles. They are massive capital investments. They provide mobility, and losing one can ruin a family's livelihood.
Of course.
I understand mail matter. The postal system is the bedrock of communication and commerce. Stealing mail is an attack on federal infrastructure and privacy. I even understand large cattle. In an agrarian society, a cow or a horse is the equivalent of a tractor. It's a living engine of the economy.
Right, highly valuable.
But coconuts. Why on earth is stealing a coconut punished 2 degrees higher, meaning more severely than stealing a diamond ring off a jeweler's desk?
It is entirely jarring to modern urban ears. But it makes perfect absolute sense when you look at the economic history and the geography of the nation where this specific penal code was authored, the Philippines.
Okay.
The legal analysis here points us to the landmark precedent of People versus Isname. The lawmakers didn't elevate the coconut because they thought it was a magical fruit. They elevated it to heavily protect the national coconut industry, which was a massive tiller of their GDP and export economy.
Okay, but why coconuts specifically and not, say, mangoes or rice or sugarcane?
Because of the unique geography of how coconuts are grown. Vast coconut plantations cover thousands and thousands of hectares of rolling land. Unlike a jewelry store in a mall or even a small fenced-in vegetable farm, a massive coconut grove simply cannot be efficiently watched.
You can't put a fence around a forest.
You cannot build a vault around a forest. You cannot afford to put security guards every 50 feet across 10,000 acres. The property is inherently, permanently vulnerable by its very nature.
Ah, so it's a deterrent based on geographic vulnerability.
Exactly. The lawmakers recognized a grim economic reality. If they didn't enact terrifyingly harsh penalties for stealing from these plantations, thieves could easily decimate the entire national industry. A coordinated group of thieves could just constantly skim from the unwatched, sprawling perimeters of these groves, night after night.
Death by 1,000 cuts.
They would bleed the plantations dry, and the owners would be powerless to physically stop them. So the law steps in to act as the invisible security guard. The extreme penalty is the fence.
That is fascinating. The law is acting as a geographic shield. But there is a really important caveat to this, right? It's not just any coconut.
Correct. The context is everything. The heavier qualified penalty only applies to coconuts taken from the premises of a plantation.
So not from a fruit stand.
Right. The law is protecting the plantation as an economic engine. If a farmer legally harvests his coconuts, hauls them to the edge of the highway, piles them up outside his house to sell to passing cars, and you steal a coconut from that pile, that is just simple theft. The severe vulnerability of the sprawling grove is no longer a factor.
Wow.
The law doesn't care about the coconut itself. It cares about protecting the macro system of agriculture from collapse.
Which brings us to another incredible agricultural rule. We talked about large cattle being protected by qualified theft, but the law gets highly specific. Large cattle means bovines, horses, mules. It specifically notes that it does not include goats.
Poor goats.
Goats don't make the cut. But what's truly wild is the distinction about the state of the cow when it is taken. Let's talk about the dead cow rule.
This perfectly illustrates how the law measures intent and economic impact.
Let's run a hypothetical. Imagine my neighbor has a massive, expensive cow. But this cow keeps breaking through the fence and eating my prize-winning petunias.
A nuisance cow.
Very much so. I complain, he does nothing. Finally, in a fit of absolute rage, I take a rifle, I walk over to the fence, I shoot the cow dead, and I just leave it rotting in his pasture out of pure spite. What crime is that?
Based on the legal precedents, that is not theft at all. That is malicious mischief. You destroyed the property out of hatred, revenge, or anger. You did not have the intent to gain. You didn't want to possess a cow. You just aggressively wanted your neighbor to not have a cow. Your goal was destruction, not appropriation.
Okay, but what if I shoot the cow dead in a fit of revenge, but as I'm walking away, I look at the carcass and think, well, it's a shame to waste hundreds of pounds of good beef. So I go back with a knife, slice off a bunch of premium cuts, put them in a cooler, and take them home for a massive barbecue. Have I committed qualified theft of large cattle?
According to the specific rulings on this matter, no. You have now committed simple theft.
Wait, really? But it was a cow. It's on the qualified list.
Yes, but you did not take the cattle as a living, functioning agricultural asset. You took the meat with intent to gain.
Wait, the state of the cow matters that much?
Absolutely. The law differentiates between the loss of capital and the loss of a commodity. To be charged with a severe crime of qualified theft of large cattle, the animal must be taken alive.
Ah, because of what it represents.
When it is alive, it is an engine of wealth. It can plow fields, it can breed, it produces milk. It is a capital asset. When you shoot it and carve it up, you are essentially just stealing steaks from a very fresh grocery store. You stole meat, a consumer good. You did not steal the living agricultural asset that the qualified theft law was designed to protect.
That is a brilliant way to summarize it. It shows how the law is constantly trying to gauge not just the physical act, but the macroeconomic impact of the act. Taking a living cow alters the farmer's future production. Taking a dead cow just alters his dinner.
Exactly. The law is weighing the exact nature of the harm inflicted on the society.
Which leads us perfectly into our next major concept. We're zooming way, way out now. We've been talking about the intimacy of a domestic servant stealing a watch or a guy stealing a neighbor's cow. Now we are moving to crimes that terrorize entire communities, disrupt regional economies, and interact with the very geography of the nation. We are talking about the outlaws and the land grabbers, brigandage and usurpation. Let's start with brigandage.
Okay, let's dive into it.
When I hear the word brigand, I picture like a 19th century Western, highwaymen with bandanas over their faces. But legally, what makes a group of criminals brigands instead of just a gang of robbers?
It is a vital and incredibly severe distinction. Brigandage isn't just a synonym for a group of thieves. It has strict elements. It requires 4 or more armed persons who actively form a band.
So there has to be 4 of them, and they have to be armed.
Yes, but the crucial defining element is their purpose. They must form the band specifically for the purpose of committing highway robbery or kidnapping for extortion.
Let me test the boundaries of this. Suppose 4 guys, all armed with handguns, meet in a basement. They get out blueprints, and they meticulously plan to rob the First National Bank downtown next Tuesday. They form a band. They are armed. Are they brigands?
No. Legally, that is a conspiracy to commit robbery in band. If their purpose is to commit a particular targeted robbery against a specific institution, the offense is not brigandage.
Oh, really?
And here is the kicker. To convict them of robbery in band, the prosecution generally has to prove they actually committed, or at least physically attempted to commit, that specific bank robbery. A mere private conversation to commit a normal robbery isn't heavily punishable until they take a concrete step toward the bank.
But brigandage operates on a different timeline.
A completely different, much more aggressive timeline. In brigandage, the mere formation of the band for those specific terrifying purposes, roaming the highways to rob indiscriminately or kidnapping people for ransom, is the crime itself.
Wow, just forming the group.
Yes. The law considers the very existence of such a group to be a threat to public order, so severe, so toxic, that they can be arrested, charged, and given massive sentences, even if they haven't actually robbed a single person yet.
It's essentially prosecuting a terrorist cell before they strike. The law treats the roaming highwaymen as a cancer that must be cut out immediately upon formation, because their goal isn't just to take money. Their goal is to make the geography itself unsafe.
Exactly. It's a crime against the safety of movement. If brigands roam the highways, commerce stops. Supply chains freeze. People are terrified to travel between towns. It stifles the lifeblood of a region. The crime is the organized threat to the community's freedom of movement.
That makes perfect sense. It's a geographic crime. And speaking of geography, let's look at the other side of this spectrum. Crimes concerning the land itself. Not stealing on the land, but stealing the land. Usurpation and altering boundaries. Usurpation is taking possession of real property land or buildings belonging to someone else using violence or intimidation. But what if you don't use violence? What if you are just incredibly sneaky?
Give me a scenario.
Let's say I live in the suburbs. I want a bigger backyard to build a pool, but my neighbor's property line is too close. So in the middle of the night while my neighbor is fast asleep, I go out with a shovel. I dig up the wooden fence posts separating our yards, and I meticulously move them 2 feet into his property.
Okay, a slow land grab.
Right. I replant them, smooth out the dirt, and go back to bed. I didn't threaten him. I didn't point a gun at him. I just stealthily, quietly stole a 2-foot strip of his land. Under the strict legal definition, is that usurpation?
It's a fantastic petty scenario. But according to the strict definitions in the code, moving the fence post in the dead of night without confronting the owner does not fall under usurpation of real property.
Why not?
Because you did not use violence or intimidation against a person to take the land. You used stealth. And remember, the specific statute for usurpation requires the mechanism of violence or intimidation to wrest the property away.
So because I was sneaky instead of aggressive, I get away with it. I just get a bigger yard and a new pool.
Not at all. The legal system is vastly more robust than that. The law has a specific, incredibly strict trapdoor designed exactly for this kind of behavior, altering boundaries or landmarks. You wouldn't be charged with usurpation. You would be charged with altering boundaries.
Okay, so they still catch me.
Oh, they catch you. And what's truly fascinating and a little terrifying about this law is how absolute it is. The legal analysis points out that the state doesn't even require proof of fraudulent intent to secure a conviction.
Wait, hold on. The prosecutor doesn't have to prove I was trying to steal the land from my pool.
No. The mere act of altering the boundary marks or monuments of towns, provinces, or private estates is a punishable crime. The intent doesn't matter. The action itself is the violation.
Why is it strict liability? That seems harsh. What if I moved the fence post just as a drunken prank?
The law doesn't care if it was a prank, or an accident, or land grab. The law is designed to maintain the absolute integrity of geographical records and property lines. Think about it. Human civilization is built on the agreed-upon lines on a map.
True.
Mortgages, taxes, agriculture, inheritances, they all rely on the physical markers being reliable. The physical markers are sacred. If you mess with them, you introduce chaos into the foundational records of society. The intent to usurp the land is your motive, but the act of moving the marker is the crime itself.
That is profound. It shows how much society values stability over almost anything else. We need to trust the lines on the map. If everyone starts moving fences, even an inch at a time, society breaks down into a literal turf war. The map must remain sacred.
Exactly. Which brings us to our final and perhaps most complex destination.
Right.
We've talked about taking by physical force and smashed windows and robbery. We've talked about taking by stealth and opportunity and theft. We've covered taking through the betrayal of intimate trust and qualified theft, and taking by geographic terror or manipulation and brigandage and altering boundaries.
It's been quite a journey.
But what happens when the criminal doesn't use force, doesn't hide in the shadows, doesn't break a lock, and doesn't move a fence? What happens when they look you dead in the eye, smile, have a pleasant conversation, and you willingly, happily hand over your property to them?
The confidence game. Estafa, or swindling. This is the realm of the con artist, defrauding another by abuse of confidence or by means of deceit. This is psychological warfare. Let's start with deceit, because the historical precedents have some incredible, almost unbelievable examples of the scams people have run to separate victims from their money.
The creativity of the swindler is truly boundless. The law defines deceit broadly, using fictitious names, falsely pretending to possess power, influence, specialized qualifications, imaginary property, or proposing imaginary transactions. It's the art of creating a flawless illusion and trapping the victim inside it.
The hidden treasure scam is a perfect example from the source. There's a cited case where a con artist pretended to be a mystic or a magician. He convinced a homeowner that there was a massive cache of gold buried directly under their house. But he claimed he needed money to buy special magic substances to extract the gold safely. The homeowner, blinded by greed, hands over a fortune in cash. The magician takes the money and vanishes. Or there's another famous case involving an indigenous victim where a swindler convinced them that a specific piece of paper had the magical alchemical power to coin silver money, but only if they waited 7 Fridays. They sold the paper for a massive sum.
It sounds absurd to modern ears. We think, how could anyone fall for that? But the mechanics of estafa don't judge the gullibility of the victim. They judge the manipulation of the perpetrator.
That's a key distinction.
Estafa hinges on the victim being induced to part with their property because of the false pretense. The deceit must be the efficient cause of the defraudation. The illusion must be the lever that pries the money from their hands.
So if the victim knows it's a scam but gives them money anyway out of pity, it's not estafa.
Correct. But if they genuinely believe the illusion and they suffer damage capable of pecuniary estimation, meaning a quantifiable financial loss, the crime of swindling is complete.
Okay, I conceptually understand the con artist, but I have been struggling with a very specific razor-thin line in the law. What is the actual structural difference between theft and estafa? Think about it. If I hand someone my property and they run away with it, isn't that just theft? They took my stuff? Why do we need a whole separate massive category for swindling?
This is perhaps the most intellectually rigorous distinction in all of property law, and it frustrates law students constantly. It all comes down to a philosophical concept called juristic possession versus material possession.
Break those down for me, because I'm getting lost in the terminology.
Let's use a classic case involving gold bars to explain it. In this precedent, the victims had raw gold bars and some banknotes they wanted to exchange. They met with the accused, a woman who promised to take the gold to a silversmith to have it worked and to change the notes into coins. She promised she would run the errand and return immediately.
Okay.
They handed her the gold. She walked around the corner and absconded with the wealth.
She lied to get the gold, she took it, and she ran. She created an illusion of being helpful. Sounds like a con. Sounds exactly like estafa.
That is what the prosecution argued. But the Supreme Court ruled it was theft.
Why? I mean, she tricked them into giving it to her.
Because of the expectation and the legal transfer of rights. When the owners handed her the gold to go to the silversmith, they expected an immediate return. They did not transfer juristic possession.
What is that exactly?
Juristic possession means giving someone the legal right over the property to hold it, manage it, administer it, or use it over a period of time. The owners did not do that. They only gave her physical, material possession for a fleeting moment to run a specific, immediate errand.
Ah, I see.
Because she only had physical possession, she was basically just a pair of hands holding their property. So her act of running away was a taking from their legal domain without their consent. Therefore, it is theft.
Oh, yeah, okay. So her holding it didn't mean she possessed it in the eyes of the law, so what would make it estafa? How do you transfer juristic possession?
Let's change the scenario entirely. What if you own a diamond ring and you give it to a professional jewelry agent? You sign a contract saying you have 1 month to sell this ring on commission. Keep 10% of the sale price, return the rest of the profits to me.
Right.
In that scenario, you have formally transferred juristic possession. The agent has a legal contractual right to hold that ring, show it to buyers, and lock it in their own safe for a month. They are in lawful, complete possession of it.
Right. If a cop stopped them on the street, they could prove they have the right to hold the ring. They aren't stealing it just by having it in their pocket.
Exactly. But if at the end of the month, they sell the ring for $50,000, put the cash in a suitcase, and flee the country, that is, estafa, by abuse of confidence. They received the goods in trust. They were under a legal obligation to make delivery of the proceeds, and they misappropriated it.
Because they already had the legal right to hold it.
They didn't take the ring from you. You gave it to them legally, transferring the jurisdiction over the object. The crime was the conversion of the asset after the legal transfer of possession.
That is a razor-thin but completely brilliant logical line. Theft is taking it from my domain, even if I momentarily handed it to you. Estafa is me formally putting it into your domain, trusting you to abide by the rules of that domain, and you betraying those rules.
Perfectly stated. And this concept of estafa covers so many vital, modern commercial transactions. Bouncing checks, for instance, is a massive part of this.
Yes. Issuing a check in payment of a contracted obligation, knowing full well that there are insufficient funds in the bank. You are buying goods with a piece of paper you know is worthless. The legal analysis mentions that this is estafa, but it also interacts with other specific statutes designed to protect the banking system.
It's a great example of the law layering protections, because it fears the ripple effects of the crime. Under estafa, issuing a bad check is a crime of deceit against the specific person. The victim who handed over the goods is defrauded. But the law goes further. The mere act of issuing a worthless check is also punished as a crime against public interest. Why? Because it damages the trustworthiness of the entire banking system. If people can't trust that a check is as good as cash, commerce grinds to a halt. The law protects the concept of the check itself, regardless of whether a specific merchant was deeply defrauded.
It's protecting the blood flow of the economy. And speaking of protecting pieces of paper, there is one last incredibly specific form of estafa that I found genuinely terrifying. It's the blank signature rule. I want every listener to pay attention to this because we all do this.
Oh, absolutely. Taking undue advantage of a signature in blank. It is a terrifyingly easy trap to fall into.
Think about how many times you've signed a blank digital tablet for a delivery driver, or hastily signed the bottom of a blank form at a doctor's office, or left a signed sticky note on a colleague's desk. The law says you have just handed over a loaded weapon. If I sign a blank piece of paper, and someone takes that paper and writes a promissory note above my signature saying, I owe John Doe $50,000, that is a specific type of estafa. They used my trust, my literal physical identity, to create a massive fraudulent liability against me out of thin air.
It's the ultimate weaponization of trust. And notice how the mechanism matters here, tying back to our earlier discussions. If the swindler stole the blank signed paper from your desk while you weren't looking and wrote the fake debt, that would likely be charged as falsification or forgery.
Oh, because they took it.
Right. But if you willingly delivered the blank paper to them, say you trusted an employee and asked them to fill in a receipt later, and they abused that delivery to write a fake debt, it is estafa. Once again, it hinges entirely on how the property, in this case your signature, entered their possession. Did they take it or did you give it?
It always comes back to the method of transfer. The law is obsessed with the gateway.
It is a vast, meticulous architecture of human morality and vulnerability codified into rules.
And what an architecture it is. Let's zoom out and try to summarize this incredible journey we've been on. We started by kicking down the doors and breaking the physical and psychological barriers with robbery. We learned that an arm through a window isn't enough to breach a home, but tripping down the stairs during a heist makes you a murderer in the eyes of the law.
Very true.
Then we put away the sledgehammer and picked up the scalpel, tiptoeing through the stealthy complexities of theft, where taking a horse for a joyride or stealing your boss's papers for pure revenge counts as a tangible gain.
And then we uncovered the deep, intimate betrayals in qualified theft, learning why domestic servants are held to a terrifyingly higher standard, why the radio technician's trust was his weapon, and why the law acts as a virtual geographic security guard for vast, vulnerable coconut plantations.
We rode out to the highways with the brigands, learning that just forming a gang with a terrifying purpose is a crime against public order. And we watched petty neighbors move fence posts in the night, realizing that altering a boundary is an attack on the stability of society itself.
And finally,
Right. Finally, we sat down across the table and got conned by the smooth talkers in estafa, learning the crucial psychological difference between handing someone your gold for a minute to run an errand versus trusting them with your diamonds for a month.
It is a breathtaking spectrum of human ingenuity and malice.
And that leads me to my final thought, a conceptual takeaway that I really want to leave with you, the listener. As we've gone through this massive legal framework, one overarching theme becomes abundantly clear. The law doesn't just protect the physical object. It isn't just about the watch, the cow, the coconut, or the piece of paper. The law protects the social fabric around the object.
That is a very profound and very accurate way to look at it.
It protects the sanctity of our homes through the rigid rules of robbery in an inhabited house. It protects the intimate trust we must place in those who live with us through the harsh penalties of qualified theft for servants. It protects the literal physical foundation of our geography and our trust in the map through the strict liability laws against altering boundaries. And it protects our commercial faith in one another, the very engine of a functioning economy, through the complex laws of estafa and bouncing checks.
It's true.
The physical property is just the anchor. The law is desperately trying to protect the relationships, the trust, and the safety attached to it.
The law is maintaining the invisible webbing that holds millions of people together in a functioning society. Without those boundaries, it all unravels.
Exactly. So here is the provocative thought I want you to mull over as you go about your day, as you lock your doors, sign your receipts, and check your bank accounts. We spent the last hour talking about physical force, smashed glass windows, bulky industrial goods stopped at checkpoints, live cows, and signed pieces of paper. But our world is changing at breakneck speed.
It really is.
Our property is becoming increasingly digital. It is intangible. Our wealth is data. Our assets are virtual coins, passwords, and cloud storage. How will these ancient, meticulous concepts of force, stealth, and trust adapt to a world you can't touch?
That's the big question.
When the vault is somewhere in the cloud and the false key is just a string of malicious code executed from across the globe, how will the law define breaking and entering? Does a hacker's code cross a physical threshold? When a highly advanced AI voice clone smooth talks you out of your digital wallet over the phone, is it the stealth of theft or is it the illusion of estafa?
It blurs all the lines.
The diagnostic muddy waters we talked about at the beginning are only going to get deeper, darker, and vastly more complex. Keep your eyes open, protect your trust as fiercely as you protect your wallet, and watch very closely where the world decides to draw its next boundaries.
Welcome to the debate. Imagine you hand your gold watch to a jeweler to be weighed, right? And the moment it's in their hands, they just bolt out the back door.
Yeah, that watch is gone.
Exactly. Now imagine a slightly different scenario. You hand your pistol to a police officer who says, they need to inspect it at the station. But instead, they take it straight to a pawn shop and sell it.
Also gone. And to most of us, both of these just look like simple textbook theft. You had something, you were tricked, and now it's gone.
Right, but under the law, one of these is basic theft, and the other is a highly complex, legally distinct crime called estafa, or swindling.
And the difference between the two, well, it isn't about the victim. It's not about the financial loss either. It hinges entirely on this invisible, almost philosophical concept that the legal framework calls juridical possession.
Right, so today we are asking a really fundamental question about how our justice system handles property crimes. Like, why does the law treat the exact same betrayal completely differently? We're looking at the razor-thin boundary between theft under Article 308 of the Revised Penal Code and estafa under Article 315.
Right, and the specific question is whether this strict doctrinal distinction actually provides a coherent, just framework for prosecuting these crimes. Or, if it just creates arbitrary legal fictions that obscure the true nature of the fraud.
Well, my position on this is that the legal distinction between juridical possession and physical possession is frankly an absolutely logically sound and structurally necessary boundary. It appropriately differentiates someone who just breaks physical custody from someone violating a formally recognized legal trust.
And my argument is that the courts have basically tangled themselves in knots over this. If you look at the jurisprudence, the sheer myriad of edge cases reveals this distinction to be highly formalistic and functionally problematic. It relies on judicial hair-splitting rather than, the substantive harm of the misappropriation itself.
Let's just lay the groundwork first so we know exactly what we're comparing here. Under Article 308, theft is fundamentally about taking personal property belonging to another without their consent, right? And with the intent to gain.
Right. The classic element of asportation.
Yes, asportation, which is really just a fancy legal term for the physical snatching away or moving of the item. But Article 315, which deals with estafa by misappropriation, requires a completely different sequence of events.
The sequence is totally flipped.
Exactly. For estafa, the offender must first actually receive the property lawfully, like it has to be handed over in trust, on commission, or for administration.
And crucially, that lawful receipt has to transfer what the courts call juridical possession, which is, the cornerstone of our debate today.
Right. Juridical possession isn't just holding an object in your hands. It is defined as a possession that gives the transferee a legal right over the thing, a right they can set up and defend even against the true owner for the duration of that agreement.
Which sounds, incredibly elegant and academic, right? Until you realize someone could go to prison for 20 years based purely on which invisible legal box a judge decides to put them in.
Well, but it's an essential box. We have to uphold the integrity of contract and agency law. Let's look at the case law to see why this really matters.
Okay, let's hear it.
Take a scenario like the one in People versus Naveo. A person formally hires a truck under a lease agreement, drives off, and then just turns around and sells the truck. The court ruled this is estafa.
Right, because of the lease.
Yes, because a lease transfers juridical possession. For the duration of that lease, the renter has a legal enforceable right to possess the truck. Now contrast that with another well-known case, People versus Isaac.
Ah, the jeepney driver.
Exactly. Here, an owner entrusts his jeepney to a driver for a passata, which is, the daily boundary system where the driver operates the route and pays a fixed fee to the owner.
And the driver in that case also decided to just sell the vehicle?
Right. But the court ruled this was qualified theft, not estafa. And I maintain this is a brilliant, necessary legal categorization.
Brilliant? Really?
Yes, because a hired driver under those specific regulations merely holds physical custody. He doesn't have an independent legal right to the jeepney. He is functionally an extension of the owner's hand.
I just come at it from a completely different way. The theory you're outlining sounds incredibly neat in a textbook, but the jurisprudence we actually have to work with exposes just how fragile this framework is.
How so?
The realities are different because the contracts are different.
Only on paper. Think about the functional reality of both of those cases you just mentioned. In both scenarios, an owner voluntarily handed over the keys to a vehicle to another person.
Sure, physically.
Right. And in both scenarios, the person took the vehicle, abused the confidence placed in them, and sold it to make a profit. Both crimes punish the exact same core act. It's an abuse of confidence coupled with an intent to gain. I wouldn't say it's the exact same act legally.
But functionally, it is. My overarching position today is that when the law tries to separate criminal liability based on the hyper-technicalities of possession rather than the reality of the deception, it creates massive, glaring loopholes. We get a system where the exact same functional harm results in vastly different criminal classifications and penalties.
Okay, let's test that then. I want to move from the broad definitions into specific employment relationships, because this is really where the tension you're talking about surfaces.
Yeah, the workplace cases are wild.
Well, we've seen how the law views the jeepney driver. Let's examine how this concept of abuse of confidence is treated differently across the two crimes, specifically looking at how the state applies the charge of qualified theft.
See, this is exactly where the illusion of juridical possession breaks it down for me. Look at how the legal framework maps out qualified theft. The law says that theft by a domestic servant is always qualified theft.
Right, because of the intimacy of the dwelling.
Exactly. The state just presumes a grave abuse of confidence. But if you look at cases involving housemates or day laborers, the courts say that theft is not automatically qualified.
Right.
They say living together might be accidental, or being a laborer doesn't automatically create a relation of intimacy.
Well, that makes perfect sense to me. I mean, a domestic servant is given the run of the house. A laborer is just present on the construction site. The level of trust is inherently different.
Wait, let me make sure I understand this. You're saying the core issue is the level of trust?
Yes, trust and proximity.
The law drops the hammer on them, punishing the breach of trust severely. explicitly acknowledging the deep confidence placed in them to guard those exact goods.
Yes, because they abused their position.
Yet, the law insists on calling it theft, simply because formal legal title or juridical possession wasn't passed to the guards. If the core aggravating factor is the breach of trust, why are we shoehorning it into a theft framework?
Because they didn't have juridical possession. They were just guards.
Exactly. It's circular reasoning. We say to the security guard, well, you didn't have legal trust over these items. You only had physical custody, so your crime is theft.
Right.
But then we say, because you abused the trust we just said you didn't legally have, we are going to upgrade it to qualified theft. We are chained to this arbitrary idea of who holds the magical juridical title. Estafa is literally the crime of swindling and betrayal of trust. Why not just call it what it is?
I see why you think that. I really do. But let me give you a different perspective. Isn't it absolutely vital for commerce that we differentiate between an employee who merely handles goods and an agent who has the legal authority to dispose of them?
I mean, maybe for civil liability, but for criminal?
Definitely for criminal. If we blur the line between qualified theft and estafa, don't we risk criminalizing simple employment disputes?
How so?
Think about the mechanics of employment. A security guard is hired to repel intruders, right? He is not an administrator of the goods in that warehouse.
Sure.
Or take a bank teller who pockets cash. They are a mere custodian of the bank's money. They have no independent right to that cash against the bank. If we call the teller's crime estafa, we are legally acknowledging that the teller had a valid, independent, juridical right to hold the bank's money against the bank's own wishes.
Well, they did hold it?
Physically, yes, but legally, that upends the entire concept of employment. The employer must retain juridical possession, or else every employee becomes an independent contractor the moment they touch company property.
But the punishment for qualified theft is actually 2 degrees higher than simple theft. We are punishing the betrayal of trust anyway.
It is not circular, though. It is layered. You have physical proximity, which is custody. The abuse of that proximity qualifies the theft, making it worse. But juridical possession is an entirely different legal dimension. It's about property rights and the chain of title, not just geography and proximity.
Okay, let's talk about geography and time then. Because the case law pushes this boundary even further when we step outside the workplace.
Oh, the temporary handovers.
Right. What happens when you just temporarily hand your property to a stranger? This really tests the temporal limits of possession.
You are referring to the immediate return exception, and I actually find this to be one of the most elegant, practical solutions in the jurisprudence.
I figured you would.
Well, it makes sense. The legal standard states that in theft, upon the delivery of the thing to the offender, the owner expects the immediate return of the thing. Let's go back to that vivid scenario we opened with. You know, the classic case of U.S. versus De Vera.
The gold bars.
Right.
Right.
You have these egret miners who want to sell gold bars. They bring the gold to the accused, who is a silversmith. They hand the gold over just so she can weigh it on her scale.
And they're standing right there.
Exactly. The owners are standing right there. The silversmith takes the gold and runs off. The court rightly ruled this was theft, not estafa.
Because, under your framework, she didn't have juridical possession.
Exactly. They handed it to her to weigh it right there in front of them. They expected an immediate return. There was no formal contract of administration or agency formed in those 30 seconds.
Right.
It provides a highly workable, common-sense standard. If you expect the item back immediately, no legal trust was transferred. It's theft.
I'm sorry, but I just don't buy that it's a workable standard. And let me tell you why. Let's put the De Vera gold bar case right next to the People versus Bautista case.
Okay. The policeman?
Yeah. In Bautista, a policeman approaches a citizen and asks for their pistol. He tells the victim he needs to take the gun to the detective bureau for examination, and he promises he will return it in 3 days.
But he doesn't.
No, instead, he goes and sells it. And the court ruled this was estafa.
Because 3 days is not immediate.
But is that really the standard we want to build our justice system on? The functional harm in both the gold bar case and the pistol case is completely identical.
I have to disagree there.
Let me finish. A lie was used to gain physical control of an object, followed by the offender walking away and misappropriating it.
Why does a 3-day timeline magically conjure juridical possession out of thin air, whereas a 5-minute weighing process does not? Both victims were tricked into handing over their property.
That is a compelling argument. I'll give you that. But have you considered the actual mechanics of what happens when you hand something over for 3 days? Let me offer an analogy.
Go ahead.
The gold bar case is like holding someone's wallet while they tie their shoe. You have purely physical proximity, the owner is standing right there, their eyes are on the object, and their control is only suspended by a physical action.
Okay, sure.
But entrusting a legal officer with a weapon, letting him take it out of your sight across the city to a government bureau for 3 days, that necessitates a transfer of legal responsibility.
But it was a lie.
Even so, the policeman is now liable for that weapon in transit. He has a right to hold it against others while moving it. That is juridical possession.
Wait, hold on. The policeman lied to get it. He never intended to take it to the bureau. He intended to sell it. The legal framework itself notes that in estafa by deceit, the false pretense must be made prior to or simultaneously with the commission of the fraud.
Right.
So if I lie to you to get your watch and I say I'll give it back tomorrow, I never formed a lawful contract of trust with you. My intent from second one was to rob you.
But you still received it voluntarily.
I just manipulated you into getting me custody. Calling that a lawful receipt that transfers juridical possession makes a mockery of the word lawful.
It doesn't make a mockery of it, honestly. It just acknowledges the complexity of human interaction. The victim intended to grant the policeman a temporary legal right to hold the gun.
Based on a lie.
Yes, but the intent to transfer the right was there. The victim in the gold bar case did not intend to grant the silversmith any right to the gold, just the physical ability to put it on a scale. The law has to look at what the parties believed they were doing at the moment of the handover.
And this brings us to what I consider the most bizarre consequence of treating these as entirely separate domains of law. We've talked about how the crime starts, right? But let's look at what happens after the misappropriation occurs.
The civil aspects.
Exactly. Because estafa is so rigidly tied to contract law, it creates absurd legal escapes that simply do not exist in theft.
You're talking about the civil resolution of these cases.
I'm talking about getting away with a crime on a technicality. Look at the Clemente case. An agent misappropriates funds he was supposed to manage. He steals the money, plain and simple. He commits the crime.
Okay.
But before a formal criminal complaint is filed, he goes to the victim and persuades them to treat the stolen money as a loan.
Right, a novation.
Yes, the court says this novation, this rewriting of the contract after the fact, converts the agency into a loan and entirely erases the incipient criminal liability for estafa.
Well, yes, because the victim voluntarily agreed to alter the nature of the relationship.
But the crime already happened. Let me give you an analogy. It's like getting caught stealing a TV out of someone's living room, but because you convinced the homeowner to sign a rental agreement for the TV right before the cops put you in handcuffs, the law says the theft never happened.
It's not the same thing.
It turns the justice system into a game of contract bingo, and it's incredibly inconsistent. If you look at another case, Javier versus People, a victim accepts a promissory note after the fraud is discovered, but the court ruled the crime of estafa remains.
Because a promissory note doesn't extinguish the original obligation.
Right, so it rests precariously on whether the victim's lawyer used the exact magic words to novate the contract before the prosecutors stamped the file. It proves the crime relies on contract law loopholes rather than the reality of the criminal theft.
That is an interesting point, I'll admit. Though I would frame it very differently. I don't see that as a loophole at all. I see that as the sophistication of the law.
Sophistication?
Yes. Think about the philosophical purpose here. Estafa must allow for civil resolutions precisely because it originates from lawful, voluntary contracts. These are often business relationships that just go sour.
A swindle is not a business relationship gone sour. It's a crime.
But the boundary is gray in the real world. Take the Barberi case from the jurisprudence. An agent withheld money from his principal in good faith because he needed it for necessary self-protection in a related civil controversy.
Okay.
The court ruled he wasn't committing estafa. If we adopt your functional approach and just treat all misappropriation as common theft, we would be throwing agents, brokers, and business partners into prison every single time there is a complex accounting dispute.
That's an exaggeration.
It's not. The strict requirement of juridical possession and the flexibility of novation, they protect citizens from having the full weight of the criminal justice system drop on their heads just for a civil breach of contract.
I understand the desire to keep business disputes out of criminal court. I really do. But my issue is that the flexibility is applied so unevenly based on status and legal jargon. How so? Well, in Clemente, the guy talks his way into a novation and walks free. In Javier, the guy signs a promissory note and still goes to jail because the court says partial payment doesn't extinguish criminal liability. The functional harm to the victim is identical in both. Money was taken, the victim was left empty-handed, and a paper promise was made.
But the legal mechanism...
And let me finish this thought, because it highlights the two-tiered nature of this whole thing. If the law is supposed to be a sophisticated tool, it shouldn't rely on whether a white-collar defendant knows how to draft a strict legal novation, while the blue-collar jeepney driver or the warehouse laborer gets hit with qualified theft with absolutely no chance to novate their way out of a prison sentence.
But that bingo, as you call it, is the bedrock of our civil society. It's the law of obligations and contracts. You cannot simply ignore the legal agreements people enter into, even if the outcome feels messy.
It's more than messy.
Let me admit something. It is murky. The case law forces us to look at scenarios that feel identical but aren't. Let's say I lend you my carabao, a contract of commoditatum, which is just a fancy legal term for borrowing something for temporary use without paying for it.
Right, a free loan.
If you take that borrowed animal and sell it, it's estafa. But if you were just a herdsman hired to watch my carabao and you sell it, it's qualified theft.
Exactly. The dead carabao doesn't care about the contract of commoditum. The owner has lost their livestock either way. The betrayal of trust is identical.
But the legal status of the offender matters deeply to the state. The borrower was explicitly granted a right to use the animal by the owner. The herdsman was just hired to watch it. When we strip away the legal status to only look at the functional harm, we start prosecuting based on vibes rather than rules.
Vibes? Come on.
Yes, vibes. The boundary of juridical possession requires incredibly careful legal analysis, yes, but it is an indispensable tool. It accurately maps criminal liability onto the complex realities of contracts, agency, and bailment. We need a way to legally distinguish the pickpocket from the embezzler, because the economy treats them differently.
We do need to distinguish them, absolutely. But I maintain that the countless edge cases we've discussed today, from Igorot gold on a scale to runaway jeepney drivers to security guards in bonded warehouses, they demonstrate a severe flaw in how we distinguish them.
We might just have to disagree on that.
When a justice system prioritizes formalistic definitions of possession over the substantive act of deceit and misappropriation, it creates an uneven playing field. It focuses on the paperwork of the betrayal rather than the betrayal itself.
Well, we are clearly dealing with a persistent, perhaps irreconcilable tension here. It's the eternal struggle in property law between upholding formal, predictable legal structures that regulate commerce and addressing the messy, functional realities of human deception.
It really is. The jurisprudence pushes us to see that the law is not always a perfect reflection of morality or even common sense. Sometimes it is just a deeply complex architecture trying to hold back the chaos of human interaction. We are asking the law to be both a strict referee of contracts and a moral arbiter of trust, and it struggles to do both simultaneously.
Which is exactly why looking at these cases through multiple lenses is so vital. We have barely scratched the surface of the legal framework today. There is far more to explore regarding the nuances of crimes against property, from the exact definitions of an unlawful taking to the precise millisecond a theft is legally consummated.
And we leave it to you, the listener, to form your own conclusion. Does the current law, with its rigid categories of juridical and physical possession, effectively capture the true nature of fraud? Or is it due for a functional overhaul that focuses more on the harm caused?
Let's circle back to where we started, that invisible property line, that conceptual fence between physical custody and juridical trust. It might be hard to see. It might zig and zag around security guards and silversmiths and policemen in ways that seem confusing or even contradictory.
Highly contradictory.
But perhaps that invisible fence is the only thing keeping our entire system of commerce from collapsing into criminal chaos. Or perhaps, as you say, it's just a legal mirage we've all agreed to believe in.
I guess we'll just have to leave it there.